Are you on interim?
They are
Yeah,
interim.
we are on.
Sit down, please. Should remind me. Yes,
Lordship. Let it be on 2nd of June, madam.
second interim be continued till next date of.
May I please, Your Lordship? Your Lordship, I beg to mention item number 21, Your Lordship. In this matter, case diary was called for, but as per instruction, it has not been received.
Lordship, in 21, my lord, I have to take the instruction also, my lord, and they are interim, my lord. Any such it has been filed or not.
Petitioner
So,
number
my lord,
one
let
is
it be, my lord, after, my lord, after 2 weeks, my June, my lord, then they are on interim, my lord.
Instructions means
Regarding-
registration of a case.
No, my lord, regarding, my lord, such sheet, my lord. There's something. But the concrete instruction I do not have, my lord. So, interim is there, so let it be on,
Your
my lord,
Lordship,
2nd of June, my lord.
Your Lordship, interim is for petitioner number 1. There is no interim for petitioner number 2. So kindly date may be fixed on
Let it be on
21st or 22nd.
21st, no, my lord. Let it be on 28th, my lord. Huh?
20th may not possible. There are
The
many
1st of
different
June, my lord.
options. 1/6. Interim be continued for the petition number 1 till next date of this. Petition number 1 occurs. Okay.
Yes.
One more, Your Lordship. Item number 29. In this matter also, case diary was called
Case
for.
diary not received.
Taking not received.
It's from Dhuburi, man.
So what is the position you are?
There is no interim, Your Lordship.
No interim. From Dhubri?
May last subject to convenience of the court.
21st.
Huh?
There is no interim, Your Lordship, actually.
No, we don't have dates. The interim may or may not be.
25th.
When?
Okay, Your Lordship.
25.
25.
Oblige, Your Lordship.
We should remind them. Interim.
May I please, Your Lordship? I beg to mention item number 43. Kindly
40?
adjourn 43. Kindly adjourn the matter for 2 weeks. Your Lordship, I am appearing on behalf of Legal Aid Council. This is P.V. Bordole.
Other side state is there in 43.
43.
43.
You are MS?
As Bhumik. On behalf of P.V. Bordole.
As
21.
MS as Bhumik appearing on behalf of MSPB Board of the Learned Legal Council. Is subjected to some personal conflicts for the Learned Legal Council is not in question. Prayer error is the matter according to the 2 weeks as an entity fixed by the ministry.
Obliged.
May I please, Your Lordship. Lordship, with the concern of the other side, I beg to mention item number 7, Lordship. That due to some difficulty, the senior counsel is out of station, Lordship. Kindly fix the matter of the 2nd of June, 2nd week of June.
Petition. You are for the petitioner.
No, I'm for the petitioner. Respond.
You are for the respond number.
Yeah.
You are for the petitioner.
Petitioner. There is an interim order.
It's to be addressed. The Learned Council have made for the response. When I term there out. 2nd week of June, you are saying. 11th of June. Interim was there. Interim be continued till next day.
May I please, Your Lordship? Lordship, I beg to mention item number 38. Kindly pass over
Item number
38, Lordship.
38.
Yes, Lordship.
Yes, what is the 38? What's a hearing?
Yes, Lordship.
Now 38 is connected with 39.
39.
38, you are for the appellant.
Yes, Lordship. 39.
And 39, some other councils are there for the appellant. You are for the appellant.
There for the respond number 2 is the same council, my lord. In 38, respond number 2 is the petitioner in the, my lord, 39.
Oh, yes, yes. Respondent number 2 is the appellant in 39.
39.
You are for the appellant in 39?
Respondent 2, T. So.
Yes, yes, respondent 2. Respondent 2 is the appellant in 39. These are connected.
Connected.
Okay.
But
It-
my lord, she is saying that my lord, in 39, response number 2, T sum, T is for T sum.
Oh, so you are for TSO,
T sum,
39.
39, my lord, response number 2. Assume kindly.
39, response number 2, yes. Yes. Acha, so you are appearing for response number 2 in item number 39. Have you taken consent of the Mr. M.A. Sheikh was there in both the matters?
Because the connected
Lordship.
matter.
M.A. Sheikh, the counsel, is the respondent number 2 in item number 30, whereas apparent in it item number 13.
Lordship, I have no instruction regarding this.
You have to take.
Same counsel.
Same counsel is appearing.
More will want to-
What is your difficulty today?
Lordship, Mr. I. Hazarika has some personal difficulty.
I, Hazarika?
Yes, Lordship.
So in connection with 39, you don't have any objection.
Yes, Lordship. Senior counsel out of station, Lord.
39, 38, there are respondent and 39, 39. What is 39 in fact? Because
Connected cross appeal may be there.
cross appeal. Maybe. Will be consent of the other side. Learn it. Consent 38, 39, direct counsel appearing on behalf of Mr. I. Hazarika for the appellate, and the learned counsel appearing on behalf of MST. So in item number in criminal appeal number 314/2015, 8.8 due to some stating that due to some personal inconvenience and this counsels and not in a position for good matter. Prayer allowed list both the matters. These are 2015 matters. 2 weeks going to list for the no like going to list the matters after 2 weeks as on a date.
Date.
You want date
Yes, definitely.
2nd of June. Both the matters.
Mass of nothing of that.
May please, your lordship. I'd like to mention item number 40. My lord, can it come
40.
after 2 weeks, my lord? Item number 40.
Mr. Cable said and it come for the petitioner and submitted that to some personal inconvenience. It's not prepared to proceed with the arbitration and accordingly paid for the actual. However, it is synthetic cases of 2015 and hence the petitioner side is hereby asked to proceed with the hearing on the next date of listing. On the next date of listing. You want any fixed date here?
As the lordship, may-
After 2 weeks, please the matter accordingly after 2 weeks as on a date to be fixed by the minister.
of like,
Wait, please, your lordship. My lord, I beg to mention item number 40 for your lordship.
40.
44, lordship. Lordship, the connecting council has some difficulty today. I seek adjournment, lordship.
No, you are for whom?
I'm with the petitioner, lordship.
Have you taken consent of the other side?
Yes, Lordship,
Mr.
yes.
J. C. Bora is
Yes,
there.
he is here.
You are here.
2 and 3, madam.
Yes.
They are enjoying an interim order, madam.
Acha, acha.
May I pray for his state, madam, if it is not inconvenient today, madam, for that.
Lordship. After 4 weeks, lordship,
This
and
hearing is also received, madam.
I pray for a date of after 4 weeks, lordship. After 4 weeks, lordship.
After 4 weeks,
Lordship.
you're seeking adjournment, staying the interim, and now you're praying for after 4 weeks.
Lordship.
Why?
Lordship, there is some difficulty, lordship here. The connecting council is having to take, lordship.
Huh?
To take. So he might
Today?
to take, lordship. That will be.
Or
So,
2 8?
To take, lordship.
Acha, acha.
He might have to undergo some surgery, lordship, next.
Ah.
So
Okay.
the coming next week, lordship, Eid is coming. And there will be Eid, lordship. So,
He doesn't. Huh? 27 Eid.
lordship. After 3 weeks, lordship,
Okay, then we're listing it on 4th of June. Go for the hearing after Eid only.
lordship.
4th of June is a hearing day.
Lordship.
You are Mr.
Essay Riaz, Lordship.
Heard Mr. S.A. Riaz appearing on behalf of Mr. G.Z. Ahmed, the learned counsel for the petitioner, and also heard Mr. J.C. Bora, the learned counsel appearing for the response number 2 and 3, and Mr. M.P. Goswami, the learned counsel, learned additional PP for the state. Submitted by Mr. State due to the toothache problem of the engaged counsel, he cannot go for, he is not in a position to argue the matter. To which Mr. Bora, the learned counsel for the response number 2 and 3 raised objection and submitted that the matter is urgent and needs hearing as the petitioner is enjoying the benefit of interim order. In view of this, let the matter be accordingly listed on 4.6 question, 4.6 so and so, with a direction to both the parties to proceed with the hearing on the next date of listing. We are listing it on 4.6.
Lordship, deeply obliged.
Let's take E bar either.
May it please your lordship. Lordship, I beg to mention item number 10 of the daily list.
Here is Rashid laid down.
My lord, on the I beg to
Which item you are saying?
item number 10 of the daily list, your lordship. On the last occasion, trial court records were called for, lordship, but it has not come today. Lordship,
Oh.
kindly fix another date.
No, 10 is a bail cancellation. We have received the case record. None.
No way.
CD also not received, your lordship.
You are the petitioner.
Yes, your lordship. Kindly fix another date, your lord.
Are the learned counsel for the petition, and it is seen from the office note that the scan copy of the DCI along with the exceeding of the receipt raised is hereby directed to issue reminder. List the matter accordingly. Yes, that's a bit about. Do not be given. Do not pass it. Cancellation of bail. 3rd of June.
Lordship, obliged, your lordship.
Lordship, I beg to mention item number 22.
Item number.
22.
Yes, what is 22, Kusami?
Bail hearing.
CD available. Do you have any difficulty?
My lord, we have lost contact with the client. So
Huh?
we have lost contact with the client.
Lost contact with your clients.
So
Then?
we are not appearing in this case.
No, you cannot say not appearing. You have filed your wakalatnama, I think. Then
My lord, from the last 1 month, we are trying to contact the client.
you are
No.
trying. Have you issued any notice and all? If
Yes.
you want to withdraw yourself from the case, then you have to issue notice. Otherwise, you appear through your wakalatnama only. You cannot just simply come and say that we are not going to appear. That is not the procedure.
One thing, my lord, we may be given the liberty to send the CD in their case. If we could.
Yes. Okay. You are Mr.
Yes, Jamal.
S.
Jamal.
Jamal. You are appearing for someone?
And I'm appearing on behalf of H. Das.
Heard Mr. Jamal appearing on behalf of Mr. H. Das, learned counsel for the petitioner, and also heard Mr. M.P. Goswami, the learned additional PP appearing on behalf of state. It is submitted by Mr. Jamal that they have lost contact with the petitioner, and since last 1 month, they could not make any contact with the petitioner. In view of this, the petitioner, the counsel, the learned counsel is hereby asked to issue notice and to give proper information to the petitioner if the petitioner intimating or the information to the petitioner that they are not going to appear on behalf of him. But full stop. Next para. Further, Mr. Goswami, the learned additional PP, submitted that the CD received. CD received and accordingly sought the permission to return back the case diary, calling for an updated. So in view of this, let the CD be returned, calling an updated one, and list the matter accordingly or declare that. Do not. 5th of June. By listing it on 5th of June, you take steps and show us the notice and all if you send any notice to your client.
May I please, your lordship? I beg to mention item number 25, lordship. In this case, CD is not yet received, lordship.
Yes, what is
20
25?
25. No, the case is ended up in FR, man. Finally,
Oh. Earlier, RD1 interim was there, no?
interim,
Interim.
it was there, man. Has to be
So it has to be disposed of.
disposed of.
So now FR has already been submitted. So no case
Yes.
is there at present. If you receive any notice from the court after the, because FR will go to the learned trial court below, and then you may get a notice, and if you have something or the other complainant has raised any objection, then only you may be summoned. Otherwise, there is no case at. So we are going to dispose of the matter.
No.
Have you understood what I am saying? There is no case at all against you. So question of anticipatory or bail, nothing survives now. So we are going to dispose of it. Don't worry, any adverse, no adverse order is there. Simply case will be disposed of as case is ended with FR. Final report has been formed. Okay. URMS?
Please, Sutiya.
25%. No? Hard MS fees. Sutiya, the learned counsel appearing on behalf of whom?
Lordship, kindly allow some time, lordship.
She may be on conflict.
No.
Okay. You just talk to your senior counsel or whoever. Simply said that case there, the final report or FR has already been submitted. So no case is there against you at present. Subsequently, what happens, it will depend. But at present, there is no case against you. Okay, you take instruction and let us know.
Date may be fixed.
No, timing she is praying for. Timing only, or what do you want? Date want. You want any date here?
Sometime, lordship.
But your counsel is present today. Your engaged counsel is present. Miss MSG Deka is there.
Kindly fix a date, lordship.
Fix a date.
Monday koi to Friday mano koi do Friday. Let it be on Friday. Friday kita. Okay, we're listing it on 15th. Okay, list ekটু click on list on 15th. And the request in best friends.
May please, your lordship. Lordship, I beg to mention item number 14,
Yes.
lordship.
14 CD not received, man. CD yet to receive.
I beg to mention item number 14.
1-4.
1-4.
CD not received, lordship.
Not received.
No.
Last time CD was called for, so kindly give a date, lordship. Letter may be fixed on Monday, lordship.
Fixing a case on Monday will not do anything because it has to be
Gwalpa.
From
from
Gauhati.
Gwalpara. Monday may not be possible. Saturday, Sunday is closed. Monday, I
Day
don't
after
think.
tomorrow, then
Let it
lordship.
be on Tuesday, Wednesday,
Tuesday, yes,
Thursday, or
Tuesday.
whatever. Next week. 14. In that case, it will be 14th,
14 no, 20, 22nd dinner.
21. We're listing it on 21. Short date.
Bibliography, lordship.
No. She did not receive. It should remain 21.
May I please, lordship? Lordship, I beg to mention item number 19. Lordship, CD was called for. They must not receive.
CD received, man.
Yes, CD received.
Received, man.
Really,
But it
my
is-
senior
it's
is
your APR version.
APR.
And because there is a note, my lord, that they have not appeared after the interim order.
Lordship, actually,
In the last occasion also, that is why it is adjourned, my lord.
Lordship, he is actually judicial custody in some other cases, so he could not
Maybe
appear.
put down for you. Why don't you file an additional affidavit bringing all these on the record? If they are in custody in other
Yes,
case,
yes,
that may be a reason. For
Lordship,
that, most probably they could not appear before the IR. It's okay. So bring all these things to an affidavit. Then only
Lordship-
come to know.
Lordship, fix another date. Lordship, I will file.
You are going to retain the case there in that case?
My lord, even not observed that retained, my lord. If it is required, my lord, then we'll send. Otherwise, we'll keep it, my lord.
Okay, in that case, at the request made by
Because may only say, no, the next date will produce the CD.
when we take the demo, we do.
Lordship,
It will come next week. We're
Lordship,
listening on 25th of December
Lordship, I will not available in 25 because Lordship,
for Eid.
Do not did you?
3rd of June, then you have to return
Yeah,
back
that
the
is why I
case.
will send back because your lordship may not say retain, my lord. That's
Oh,
my
yes.
prayer, my lord.
3rd of June করে দিও updated CDB call এটি request করে দিব switch matter is item CD receive return the case diary fix the matter on 3/6 uh, 3/6 করি interim continuing your interim because if this is the conduct of your client then may be difficult. Okay.
obliged, Lordship.
My lord, I highly anticipated bail application last week, my lord, Friday. Can it be on day after tomorrow, my lord?
No, we are
Wait.
not taking any mention matter. You make a mention before court number 8. Court number 8.
Please, Your Lordship.
Yes.
I have instruction to withdraw this bail
Withdraw
application.
this one. Heard Mr. S. Nawaz, still unconscious for the petition. Also heard Mr. MP Goswami, still an additional PPA, submitted that as by instructions of his the petitioner. He wants to withdraw this. Prayer allow, where they could dispose of.
Deeply wrong.
May I please, Your Lordship? So there is an application for regular bail on behalf of 5 accused persons, Lordship. Under section 103 is the principal offense, Lordship, in this case. In fact, it is a case of, Lordship, mob attack on the victim, Lordship. The informant has lodged an affair stating that her son was having an affair with accused number 1. So when he went to her village to meet him, there was a group of people, Lordship. They had assembled in the area. This boy was beaten up and thereafter, Lordship, he was taken to the hospital, Lordship. There, after one day, he has succumbed to his injuries. Now, these persons have been picked up, but these persons are not mentioned in the FIR. They are not named accused. In fact, they came to the place of occurrence only after the commission of the offense. They, having heard Allah in that place, Lordship, hue and cry was made. They, in fact, came there and they tried to pacify the crowd. These are the people, Lordship, these are the accused person who came to the place of occurrence after the commission of the offense. And they were arrested on 19th of April. And as far as the technical ground is concerned, that I have taken, that if I may take your lordship to the their notice under section 47 and 48, that has also not been complied with by the investigating agency in letter and spirit. These 2 pages have been mentioned. May I take your lordships to page number 25, lordship?
25.
That is the notice served under section 47. Lot of questions, lordship. They are in the form of certain printed form, but nothing concrete regarding the specific grounds of arrest against the accused person. The 47 notice has to be served upon the accused person. That is a vague notice which has been served. The signature of the accused was no doubt taken. And thereafter, section 48 notice which was served on the family members, that also is silent as regards the basic fact constituting the offense. So my respectful submission is that the arrest effected by the investigating agency is illegal, lordship. The remand per se is illegal. That is in violation of Article 21 and 22 of the Constitution of India.
Yes.
Lordship, let us CDB there because it's from Sonapur, my lord. Then we can inspect whether regarding the statements of the other accused persons also. And because in page 21, I have seen, my lord, their names have been come out, my lord, after the investigation, not after lodging at the time of lodging, my lord. Perhaps it is not there, but after the investigation, these names came out, my lord. So,
For a short day, lordship. From Sonapur. Short day.
By state,
22nd.
22. No.
We are listing it on 20.
20.
Oblige.
Yes.
May I please, Your Lordship? I'm on behalf of Mr. M. Soikia.
Acha.
The petitioner entered into a sale agreement for selling of residential house and total amounting to rupees 39 lakhs. And she received amount of rupees 23 lakhs from the complainant as advance payment. And she approached for the permission of the property, but she could not get permission as because the property was already hypothecated by the SVD finance. Therefore, she decided to not to sell the property. And then the complainant visited to her house and compelled her to vacate the property. But she requested to give 1 month time for vacate, as because of she is a single mother and she has minor children. But the complainant denied to give time and instruct to vacate immediately and give threatening to arrest her and send legal notice as reply notice
No FIR has
annexed
been registered till now.
page number 20.
FIR is not there.
FIR is not registered, Your Lordship.
So who will the want to sell your
You can see AB.
Repeatedly threatened the petitioner to
Threatened by the private person. In that case, where A will not lie, because there has to be some apprehension of arrest.
Apprehension of
That
arrest,
is not there.
Mane
Only a notice has been sent to him. Only the notice has been sent, by the complainant.
complainant is Om Prakash.
Om Prakash.
This petitioner wanted to sell her property,
Yes, madam.
but subsequently she could not execute.
Yes, she could not execute. She has taken the advance, but she could not execute. That is why notices have been sent, madam. So,
That much only.
oh yes, madam, nothing more, madam, because this cannot be a
It
case
says
of anticipatory bill.
civil matter.
So
Protection
it
may
may
be
not
done.
be a case for anticipatory because notice is legal notice we sent.
Yes.
Obviously, because you have taken the money to sell, and obviously he will issue notice for returning the money or for selling this one. There may be, but at present there is nothing to.
Nothing is there, madam.
Yes. Anyway, you are suspecting the case is to be lodged in under Dispur police station.
Yes, sir.
So we'll call for the report. In a short date, we are calling for the report.
And, in that
And
case,
that
madam, there
cannot
is
be a case for your arrest also because there is a agreement for sale and the agreement could not be executed due to some reason. So that may not be a case for
She is willing
an
to
agreement.
repay the amount, Your
Huh?
Lordship. She is willing to repay the amount.
Very
But
nice.
time may be done.
Because legal notice is already there.
Kindly
Anyway,
see,
we are
madam,
calling
there
for
is
the
no averment in the petition, madam, that police is visiting or whether they have been called by the police.
what
Nothing.
basis will
Only what basis, madam, in chain. Only thing they stated that complainant side repeatedly visited the house of the petitioner, showing fear of arrest by police.
Pretend
That,
her and
that cannot be a ground for.
how they can
Madam.
without. Anyway, you are MS
R. Doctor.
R.
Doctor.
Doctor. I heard MS R. Doctor, the learned counsel appearing on behalf of Mr. M. Saikia, the learned counsel, the petitioner, and also heard Mr. MP Saikia, the MP Kusami, the learned additional PP, appearing on behalf of said. This is an application under section 482 PNSS, praying for grant of pre-arrest bail to the petitioner as apprehension of arrest in connection with Dispur police station, in connection with
No police station
connection
is
with
given.
Dispur police station.
Yeah.
Dispur police apprehension of arrest in any case to be registered under Dispur police station. It is submitted by her that there was an agreement for sale between the petitioner and the respondent number 2 for selling of a residential flat. But due to some due to some but subsequently the agreement the sale could not be executed as the property was already hypothecated in a bank. But the respondent is now threatening the petitioner, and for which she had to file the present petition seeking anticipatory. Next one, Mr. Kussamili Lanet additional PP submitted in this regard. A report may be called for from the Dispur police station as to whether any case has been registered against the present petitioner under the Dispur police station. And considering the submission made by Lanet Council for both sides, let a report be called for from Dispur police station as to whether any case is registered against the present petitioner. Yes, when it can be.
Date next 20.
20 20.
May it please your lordship. Lordship, this is an anticipatory bail application. Lordship will find the FIR on page 15, lordship. May I read the FIR? I have the honor to report that on 12/4/2026 at about 2:10 a.m., officer in charge of Bihupuria Police Station, Sri Parthopotim Gogoi, along with the police staff, conducted routine vehicle checking in front of the Bihupuria PS and intercepted one vehicle bearing registration number such and such, which was proceed from Nagaon towards Bangalmara, Laluk under Lakhimpur district. Upon checking the vehicle, 4 persons apprehended, namely Abu Hanan, Saddam Hussein, Shahamul Islam, and Motiur Rahman. During such, the above mentioned persons were found in possession of large amount of cash suspected to be connected with the illegal activities. So it's illegal. On being questioned, they failed to satisfactory explanation the source of money. A total sum of 3,50,000 only was recovered from the said vehicle. Accordingly, the accused person were brought to the police station, kept in safe custody for further inquiry and necessary legal action. During interrogation, the accused person confessed they have involved in the illegal fake gold business. They further disclosed that they had cheated an unknown person from the state of Odisha. As per the statement on 11/4/2026, at about 3 p.m., they meet the said victim at Dihang Overbridge and Nagaon after prior communication to finalize the deal following the Assam election 2026. As per their plan, one of the accused, namely Saddam Hussein, approached the victim and assured him to that fake gold would be delivered upon the payment of such 3,50,000. After receiving the said amount, the accused person did not deliver the fake gold and fled away from the spot towards Lakhimpur. In view of the above cognizance, the case was registered, lordship. Specific allegation against the 4-person, lordship, recovered from that 4-person, lordship. I have annexed the seizure list that is on page, lordship, 21, lordship. Now, what happened, lordship, in this case, lordship, one person was arrested and he was released on bail, lordship. That is on page 23 onward. Lordship, what happened in this case, lordship? This when releasing this bail, lordship, in page 23, paragraph number 3, lordship. 4, lordship. IO of this case has prayed for allowing him to take the arrest accused person, namely Nabi Hussain, in the police custody for 2 days on the ground for thorough interrogation in order to ascertain the nexus and involvement of the accused person with the other associate engaged in the similar offense suspected to be fake gold transaction, to trace out co-accused Baharul Ambani. He was not named in the FIR. Nothing in this, nothing has been recovered, lordship. His name is first appeared in this bail order, lordship. That person was granted bail who was arrested, lordship. Why this person was named, lordship? What happened, lordship? This person, lordship, kindly come to the page 30. earlier occasion, Lordship, remember when bail was moved before this court, Lordship, when this petitioner was tried to arrest by some police personnel in civil dress, Lordship. Probably, Lordship, remember that case, Lordship. That case, Lordship, after he escaped from the police custody, Lordship, then Lordship, he abusing the police, Lordship. That was reflected in the order that is on page 31, paragraph number 6, Lordship. That case, he got the bail, Lordship. When he got the bail, Lordship, subsequently this case, Lordship, one after one, Lordship, the police is harassing this petitioner, Lordship. Paragraph 6, Lordship. Orders, Lordship. Order started from 30 and paragraph 6,
Yes,
that is on
I've
page
seen.
31, Lordship. That is the case, Lordship. He is Lordship, otherwise no one involved, Lordship. Since that time it was happened, Lordship, now police tries to, Lordship, implicate him in one after another case, Lordship. This is the case, Lordship. He is ready to cooperate, Lordship. Nothing has been recovered. The gold, that amount was recovered, Lordship, prior to the election, Lordship. They are suspecting, Lordship, something is there, Lordship. But this person was not named by the co-accused, Lordship. Only police is implicating him, Lordship. Try to implicate him, Lordship. This is the case, Lord. Otherwise, he is ready to appear
Well,
because he is.
my lord, there are 4 persons arrested. And after that, my lord, his name, my lord, came up, my lord. And it cannot be said, my lord, they have not named by the co-accused, my lord.
They
may-
were, Lordship.
They may be one of the, my lord, associate, my lord.
Lordship.
Earlier also, the one that Mr. Chaudhary had submitted,
My lord,
some police personnel came as per the other side
arrested.
in a civil race
Lord,
to arrest this Baharulot.
lord,
So he has several cases.
yes, several cases.
So some persons helped him to escape or he
Yes.
fled away from
Yes,
there.
ma'am.
Now, maybe Mr. Chaudhary rightly submitted, maybe, I don't know.
Yes,
But there are cases against him.
cases,
Also,
page
in
31,
this
that
case of
one
Pegu.
order has been annexed, my lord. It
Hmm.
also states, my lord, several cases, my lord, regarding to.
He is on bail, Lordship.
He
He is in
registered
bail,
cases, my
Lordship.
lord, 109, 108, my lord, everything, my lord. Several
That is
sections
for the
are there,
Lordship.
my lord.
That happened, Lordship. One police has, Lordship, tried to arrest him, Lordship, in uniform, Lordship, civil dress, Lordship, without disclosing their identity. Lordship probably remember this case.
That's what I'm saying.
Yes.
In
Lordship,
that
he is
case,
ready.
he fled away
My
and then the
lord,
case
this-
was there.
Yes, man, this is not a
He is
very
in
plain
bail,
and
Lordship.
simple, my lord, like
Not-
others, man.
not
So let the CDB
It's
there,
the DB call.
my lord.
Some protection, Lordship. He is otherwise, Lordship, this
This is
case,
not a case of protection.
he has to appear before the police station, Lordship, for in this case also, Lordship. That previous
Let
case,
us
Lordship.
see his involvement, how people is saying that he is involved. Let us see. We'll call for the case diary, yes, when it can.
This time, man, you don't know. Keep it. Even then, next week, we will open up an eye.
Lordship, on Monday, Lordship.
And it may not be my
Because Lordship, he is not,
Lordship,
Lordship, he is on run, Lordship.
26. 26.
Lordship, some protection because he is, Lordship, already, Lordship, cooperating with the investigation in the previous case also, Lordship.
Let us see. Previous case, he was not cooperating. After arrest, he is cooperating.
No, Lordship, he was, there was an allegation of Lordship, because of Lordship, they are trying to arrest this person, Lordship, in civil days, Lordship, that's what it is.
Yes, okay. 26/5, please.
Yes, that's
God bless.
May I please, Your Lordship?
Yes, my search sheet laid down, my lord.
64 days behind the mandatory.
Search sheet laid down. Search sheet laid down on 33/2026, my.
Heard Mr. D. Mehdi, the learned counsel for the petition, and also heard Mr. M. P. Goswami, the learned additional PP, appearing on the. It is submitted that by Mr. Goswami that this case has already been translated by CS number
48/26, dated 33/26.
26. बाकी लिखे also लिखो Mr. Mehdi, the learned counsel for the petitioner, further submitted that the accused petitioner is in custody since last 64 days. And hence considering his length of detention, DPR may be considered. Next, but in the as the case has already been charged, that's You appear for a regular bail, let us see. Otherwise, we're disposing the record. Yes.
CD received, Lordship.
Yes, 12 is appearing. 12 is also Mr. May, you are appearing. CD received here.
Yes, CD received.
You
Lordship,
are for the informant.
yes, I am putting. Lordship, before proceeding, Lordship, informant name in the cost title, it was we have implemented the informant name because the case was amicably settled, but informant name was wrongly. It was a typological error. Actually, it was the person who is implemented as the informant. This person is informant's husband. So if Lordship allows, then we will proceed. Otherwise, we will amend the cost title. Lordship. Otherwise, the correct informant has filed the wakalatnama.
So you have appeared filing wakalatnama for whom?
Lordship, I'm appeared on behalf of the S. Hussain, who is the English counsel of this, and
No, I can understand, but the response number 2, what Mr. Mehdi is submitting, that it is wrongly named as Shah Jahan Ali because who is the husband of the informant.
It
he
should,
is
She is
the
not the
husband,
informant.
husband of the informant.
it should be
Husband of the informant. So you are appearing on behalf of
Suj-
husband only.
no, it should be Suzizan Nessa.
Yes.
Yes.
Yes, Lordship.
Can you tell us you have appeared for Suziran Nessa or whom?
Actually, they wrongly mentioned this. He's
What you say? Any character name pay could
I'm on behalf of the informant, Lordship.
What to guess, Mr. Sharma? Otherwise, we can give a 2-3 days date. You can just
We
file
will
a
amend the cost title.
and the cost item. Because it may create again another problem in police station also.
Not.
If
On-
suppose any order is there, isn't it?
On Friday, Lordship.
Yes, maybe on Friday, hard Mr. Immediately learn council for the hard Mr. B. Sharma, the learned the respondent CD is also received, but it is submitted by Mr. Meeting that inadvertently the respondent number 2, the respondent number 2, he is stated to be the informant, is actually the husband of the informant. Husband of the informant. Accordingly, he submitted that there's an inadvertent mistake in mentioning the name of the informant. In view of this, let the cost title be corrected or modified. The petitioner will be at liberty to file an additional affidavit for the said modification of the cost title. In view of this, she will be retained and list the matter on Friday, 15 so and so, enabling the petitioner to modify or correct the cost title. Remember, cost title of the petition. We are listing it on Friday. You just simply file the application. We are retaining the case time. CDB retained till.
Deeply obliged.
May I please your lordship? That's a regular bail petition, lordship. He was arrested on.
Yes, what is it in item number 13?
Yes.
CD
CD
receipt.
received, Lordship. This is the statement of the.
There are two affairs, lord.
Huh?
Caused by the same informal lordship against me, lordship. On the very same day also, lord.
Same day
Lordship.
means?
Two affairs, lordship. There are two affairs, lord.
Acha.
Lordship, find the first affair at page lordship 15, lordship, original lord. Lordship got it, lordship.
Yes.
May I read it, lordship? With due respect, I am Juman Chetia, daughter of a resident of Hatikor Dhemaji, Uttala. Due to laws, a pylon attempt to rape conducted by Mr. Promoter, that is the present petitioner, lordship, at my residence on 14/4/2026 at about 5:30 p.m. during the absence of my parents. This is the first alert. Allegation is that he attempted to commit a rape.
No, attempted to commit
Just,
rape on and in absence of her parents.
Yes, lords, that is the
Then?
first one.
Ah.
Then lordship, lordship will find the second of her lordship. That is at page 18, lordship, that is the vernacular one.
Yes.
Read lordship. যৌন নিৰ্যাতন সম্পৰ্কীয় অভিযোগ মহোদয় সন্মান সহকাৰে আপোনাক জনাও যে যোৱা ইংৰাজী 14/4/2026 তাৰিখ মঙলবাৰে বিয়লি 5:30 বজাত মই ঘৰৰ অকলশৰে থকা অৱস্থাত ধেমাজি নগৰ 4 নং ব্লকৰ নিবাসী শ্ৰী প্ৰমোদ আগৰৱালা পিতা স্বয়ংসূৰ্য ঘৰৰ ভিতৰত প্ৰৱেশ কৰি বলপূৰ্বকভাৱে মোক সাৱটি ধৰি প্ৰথমে গালত চুমা খায় আৰু যৌন নিৰ্যাতন কৰিবলৈ উদ্যত হৈ শৰীৰৰ বিভিন্ন অংগত স্পৰ্শ কৰি যৌন নিৰ্যাতন চলায়। This is the second one. Lord. If lordship will go by this affair, Lord, some sexual assaults may be there, Lord. And person, that is the attempt to rape.
Which was registered, maybe
A person is registered, Lord.
first FIR was registered.
Lordship. Lordship. That is at page 16, Lordship. Received and registered by PS case number so under section 329(1), 64(1), 62 BNS.
But the other one also produced before the
It is on record.
judicial magistrate.
Yes, yes, Lord.
It is on record.
It is on
But I
record.
mean, that is a maybe considered as a statement under 160.
That is. But Lordship, actually nothing was happened, Lordship. No forces there as per the first FIR, Lordship.
So
Neither
your
he,
petition is in custody now.
yes, yes, Lord. He is a 16-4, Lordship. Neither he tried to disrobe herself or himself or try to disrobe the victim also, Lordship. No injury at all, Lord. It's the local resident, Lordship, 59 years old.
So why the one girl will lodge an FIR against you?
Actually, what happened, Lordship? On the 14th-4, Lordship, that is the Bohag Bihu, Lordship. I believe he went to the house of the petitioner, Lordship. They are recorded relationship, even, Lordship. When he trying to at the time after left from the house of the victim, Lordship, he kissed her by saying that Ma Zaunde. As per introduction, that is the incident, Lord. And affair was lodged on 15, Lordship, at 5:30, not on that day of the alleged incident. It was lodged on 15 at 5:30 p.m. And no explanation was there, Lord. It is an afterthought, Lordship. So I may be allowed to go on bail, Lordship, if any condition, Lord.
Yes, sir.
Lordship, I leave it to Lordship. He is a relative of the accused, distant relative. And Lordship, the 183 is clear. Attempt was made, however, he did not succeed. Your Lordship, he has been in custody since 16/4.
16/4.
Some strict condition away. I leave it to Lordship.
If the Lordship, the second affair will be treated as the statement, Lordship. Statement of victim, then Lordship, definitely, Lordship, no attempt was there, Lordship, to. So I may be, if that is the
But
true, Lordship.
the statement of the victim which has been recorded, it's quite believable because the person may take that advantage.
That has happened.
There are many instances. It cannot be said that it has happened.
Yes.
Obviously, he is in custody for 16/4. That is different thing.
Yes.
But otherwise,
Yes,
see this thing can it may be a believable story.
Yes.
Otherwise,
And the statement recorded on the 161 also Lordship, it's consistent. Lordship.
consistent.
There's no doubt about it. And she has also.
Because she has not brought any other exaggerated things.
Yes, yes.
The things, the visualize, if you can visualize it situation, that is the only situation she brought in there.
After the incident, she telephonically informed her parents also. Just right after the incident. So that is also on record. Also.
But this is not a
Such
case
an
that
elderly
after
person, he-
raising hue and cry, Lordship, the accused is a plead that they are from, Lordship. That is also not there.
Huh?
No hue and cry, Lordship, no any alarm, Lordship.
She came out immediately outside the
Your
house.
state of mind, Lordship, cannot be assessed by us, Lordship. What
Hmm?
she went through, Lordship. So to
But
stay, it is
Lord,
very
kindly consider the length of detention, Lord.
Oh. Item number 30, na? Heard Mr. B.K. Gogoi, done counsel for the petitioner. Heard Mr. B.K. Gogoi, the learned counsel for the petitioner, and also heard Mr. B. Sharma, the learned additional brief appearing on the behalf of Civics Department. This is an application under section so and so in so parking liquid. Next, it is submitted by Mr. Gogoi, the counsel for the petition, that the present petitioner is innocent and he has not committed any such offense as alleged in the act. However, it is affected on the day of incident, he visited to the place of the informant, and after having a glass of water, he just simply said goodbye to the victim girl by kissing on her forehead. By kissing on her forehead. That apart, nothing had happened. That was India. More so, 2 FIR has been lost by the victim the same date with the same set of allegations. However, the second FIR is considered to be a statement made under section 160 CRPC. Next para, Mr. Sharma, the learned addition submitted in that the CD reveals sufficient incrementing materials against the present petitioner, especially the statement recorded in the statement of the victim recorded under section 180 and 183 BNSS. Considering the submission made by learned counsel, I have also placed the case diary and the statement made by the victim, and it is seen that there are sufficient implementing materials brought against the present petition by the victim in her statement. However, considering the length of detention already undergone by the accused petitioner, this court is of opinion that further custodial interrogation may not be necessary for the purpose of investigation. Accordingly, I find it fits to extend the privilege of bail to the present petitioner. To whose satisfaction this one?
CGM, Lord, Dhemaji.
CGM
Lord.
to the satisfaction of CGM. Back in format of 30,000 with 1 security.
Deeply obliged, Lord.
Fifteen, Lordship, CD has not been issued.
Not received.
Not issued.
In item number 15, my lord.
Huh?
In item number 15 and 30 is out of the same FIR, my lord.
CD not received here.
Here the person, my lord, your lordship, remember, my lord, in item number 30, your lordship has granted interim bail to the accused persons, my lord. In item number 15, my lord, he is one of the brother, my lord. Earlier, the informant lost the FIR which was bailable in nature. Subsequently, the second FIR has been lost.
15 and 30.
15 and 30, my lord. 30 is AB, my lord, where your lordship has granted interim bail, my lord. And 15, my lord, he is in judicial custody, my lord. He is a headmaster of a school, my lord. It's a quarrel between the brothers, my lord. And first FIR was bailable, that's why second FIR has been lost, alleging some non-bailable allegation, my lord. And in this case,
No,
he
we
was
are not going to pass any order. We have to pay.
he was arrested, my lord, behind bars.
Where from
Immediate,
it?
Lordship. From Hajo, Lordship.
Haju.
Hajo.
Hajur prohibited dates upon him. Two zero. CD not received. CD not received. Issue reminder. This the matter on 20-0-25. Item number 30. Item number 30. They are in interim.
Interim there.
Item number 30.
31.
CD not received. Issue reminder. Interim be continued till next set of listing. List the matter accordingly on 25.
Wait.
Obliged.
May I please, Your Lordship? My lord, this is a
Yes,
bail
16,
application
just a
and the
second.
accused.
16, what is the position?
Yes, good. She is.
It is there.
Okay.
My lord,
Yes.
the accused is in jail since 8/3/2026. And
8-3.
8/3, more than 64 days in custody. And the FIR was, and the section is 108, abatement to suicide. My lord, may kindly come to page number 12 and 19.
12.
Is the FIR.
Page number 12.
Page number 12 and page number 17 is the FIR. মহোদয় বিনীত সন্মানপূৰ্বক নিবেদন যে এজেহা মোৰ ঘৰৰ শিৱসাগৰ ঢুলীয়াপাৰাত গতি ইংৰাজী 27/2/2026 তাৰিখে ৰাতিপুৱা 10 বজাত মোৰ বোৱাৰী শ্ৰীমতী পাপৰি বৰুৱাই মোক ফোন যোগে জনাই যে মোৰ সৰু ভণ্টি শ্ৰীমতী ইনুপমা হাজৰিকা ডেকা নিজৰ ঘৰত আত্মহত্যা কৰিছে। উক্ত খবৰটো পাই পোনে পোনে গুৱাহাটীলৈ আহো। পৰিয়ালৰ বাকী সদস্যৰ পৰা খবৰ পাওঁ যে মোৰ ভণ্টি গুৱাহাটী প্ৰতীক্ষা খ্ৰীষ্টান বস্তিত এপলো হস্পিটেলত ভৰ্তি হৈ আছে। মই হস্পিটেলৰ আহি ভণ্টিক দেখা কৰোঁ আৰু তাই প্ৰত্যক্ষ কৰি তাইৰ ডিঙিত ৰছীৰ চিন দেখা পাওঁ আৰু ডক্টৰৰ লগত আলোচনা কৰি গম পাওঁ যে মোৰ ভণ্টিৰ অৱস্থা বৰ শোচনীয়। ইংৰাজী 28/2/2026 তাৰিখে মই আৰু মোৰ পৰিয়ালৰ বাকী সদস্যৰ লগত মই মোৰ ভণ্টিৰ স্বামী ঘৰলৈ যাওঁ আৰু তাত গৈ ভণ্টিৰ কোঠাটোত প্ৰতীক্ষা কৰোঁ আৰু দেখা পাওঁ যে এখন সৰু গামোচা 2 টুকুৰা হৈ বিচনাত পৰি আছে আৰু গোটেই কোঠাটো সৰিয়হ ছটিয়াই থৈ দিয়া আছে। মোৰ ভণ্টিৰ স্বামীয়ে জনাই যে সেই উক্ত গামোচাখনেৰে চিপজুৰি লৈছিল কাৰণ মোৰ ভণ্টিৰ ডিঙিত থকা চিহ্নৰ প্ৰমাণ কৰে যে তাই এডাল ৰছী শৰীৰে তাইৰ স্বামীয়ে চিপজুৰি লগাইছে। মোৰ ভণ্টিয়ে আজিৰ পৰা প্ৰায় 5 মাহ মানৰ আগৰ পৰা মোক জনাই আছিল যে তাইৰ স্বামী শ্ৰী উদয় ভাস্কৰ ডেকা এগৰাকী বিবাহিত মহিলা শ্ৰীমতী নানু বৰাৰ লগত অৱহিত সম্পৰ্ক আছিল আৰু যাৰ পৰিপ্ৰেক্ষিতত উদয় ভাস্কৰ বৰুৱাই মাৰপিট কৰিছিল। যোৱা 28/2/2026 তাৰিখে মোক ফোন যোগে জনাই যে গুৱাহাটীত এখন হোটেলত তাই আহোঁতে দুইটাকে অংগ অৱস্থাত ধৰা পেলাই তাই লৈ হুলস্থুল কৰা তাইৰ মুখত ধৰি বান্ধি দিছিল। গতিকে এই সম্পূৰ্ণ কথাবিলাক প্ৰতিষ্ঠা কৰি গম পাওঁ যে মোৰ ভণ্টিক তাইৰ স্বামীয়ে উদয় ভাস্কৰ ডেকাই প্ৰচন্নতা কৰি পৰা আত্মহত্যা কৰিবলৈ বাধ্য হয়। My lord, now in this FIR, once in one side she states that her husband, the husband of the deceased tried to strangulate her in one part, and later part she changed the version and says that abatement to suicide. My lord, the entire story is a fragment of imagination. I was not present at the time when my wife committed suicide. I was on the way to home when my wife called me through a video call and told that she is ending her life. I ran to my home, broke open the door, tried to save her, and I took her to Apollo Hospital. For more than 1 month, I was treating her. And thereafter soon, I took her to the hospital. I went to the police station, but the police station has stated that the hospital authorities had informed. So therefore, I couldn't write formally anything to the police station to inform about the matter. My lord, now the entire allegation against me is that my wife has alleged to have stated her sister. There's nothing, no suicide note, nothing was there. And everything is a fragment of emotion because she was married to me, it's a love marriage. And one more point, my lord, we were married for more than 9 years. And we had no issues between us. And we have tried for IVF. And that's why she was going for through mental distress for quite a few years. I have enclosed documents, my lord. We have tried three times. And that is the mental disturbs he was going through. But the entire allegation is false, my lord. And I was arrested and I was behind bars for more than 64 days. And the IO might have taken a statement.
My lord, here, my lord, firstly, my lord, I should say, my lord, the opinion of the death is kept pending, my lord, for the receipt of the FSL report, my lord, for chemical analysis, my lord. So that is one part, my lord. If the lawsuits, we have to wait for the, my lord, final PM report, then we should not go to the merit, my lord, of the case, because there are certain materials that are there against this petitioner also, my lord. So if can wait for the, my lord, the final medical PM report, my lord, because it was kept pending till receipt of the FSL, my lord. And the FSL in the PM, my lord, it stated that there is some confusion in the occipital area of the scalp and also some 5 centimeter middle bluish greenish in color. There is some confusion in the occipital area of the scalp. That is why perhaps whether there is any assault or not, that can be only ascertained after getting the final medical report.
But otherwise, the leg portion is dissected.
Yes, my
For
dissected. And otherwise, my lord, but it's a ligation mark is there in the neck, my lord. That is there. But the opinion is kept pending. So if we go for the merit, my lord, then we have to see the materials against him, my lord.
For opinion, man, which part has sent for FBC, or any brain matter or what? Why final opinion is waiting?
Perhaps, my lord, surgical detection. Perhaps for the, but it is just a test for, my lord, presence of any human semen and all, my lord. That is
Human
semen. That is for that purpose. A notice there, my lord, here. It has come, my lord. And there is a gave negative result for the presence of human semen. That is the, my lord, of the FSL, my lord. One report, my lord.
No, I'm saying what I'm saying.
Yes.
Otherwise, PM report is there.
PM report is there.
We have found there are some contusion was found in pain or whatever there was scalp present. That part you are saying that the final opinion is still awaited.
Yes, that is why it was
because it has sent for FSL. I'm asking what result they are awaiting. What kind of FSL?
that result has come. It is stated that, my lord, that gave negative result for the presence of human semen. That is the one FSL report, my lord.
Human semen for the FSL report.
Human semen. But
was there any allegation of
there is no allegation of that.
That kind of allegation
Yes,
is
my lord.
not there.
Or else there would be some other FSL report also, my lord. Only that report is there, one.
Okay, that is the medical part. Otherwise, they are married. There are materials.
There are materials, my lord. Some of our witnesses stated that because he has some illicit relationship with another married woman, my lord. And for that, there used to be quarrel between the husband and wife, my lord. In one such occasion, my lord, my lord, in a hotel, my lord, they could apprehend them, both of them, in a compromising situation, my lord. This all led to the, my lord, there's a quarrel between them, and also regarding the other witness and the my lord, complainant, they have also stated that there is something between them that led to the suicide. And the statement of this petitioner also stated that he has admitted that position. Admitted that position, that there is some relationship with other women.
But tell us otherwise 64 days behind the bar.
Otherwise 64 days. That is.
Heard Mr. C. Pupang. Heard Mr. C. Pupang, the learned counsel for the petitioner, and also heard Mr. M.P. Goswami, the learned additional PP appearing on behalf of said respondent. And it's an application under section so and so in connection with so and so. Next para, it is submitted by Mr. Pupang, the learned counsel for the petitioner. that the present petitioner is innocent and has not committed any such offense as alleged in the affair. They got married, or they got married since their marriage took place about 9 years ago. But as they are not having any issue, the petitioners they are trying for IVF for a child. But for these reasons, the victim had undergone some mental depression, and on the day of incident also, she made a video call to him, stating that she is going to end her life, and for which she rushed to the house and somehow took the victim to the hospital, admitted in ICU, and was there with the victim. But she could not, but she did not survive, and thereafter the FIR has been lodged with some concrete allegations. Further, he submitted that the accused petitioner got arrested on 8/3/2026, and thus since last 64 days he is behind the bar, and IO got sufficient opportunity to interrogate him, keeping him in custody. However, the petitioner is still ready and willing to extend his cooperation in further investigation of this case. Next, Mr. Goswami Dilani, VP, submitted in this regard that the PM report is available, wherein one ligature mark as well as some contusion was found in the scalp of the victim, and the FSL report also says the FSL report is also negative, showing presence of no spermatozoa, no semen.
Yes. And others FSL also perhaps it is awaiting, my lord. It is in my stomach, portion of liver, gallbladder, and kidney that they are also, my lord.
No absence of, there is no found no semen on her vaginal area. But the one more FSL report is still awaited, and hence the final opinion could not be given by the doctor. However, Mr. Goswami submitted that there are sufficient incriminating materials against the present petitioner, and as per the witnesses, the victim might have committed suicide due to illicit relationship of the petitioner with a married woman. Considering the submission made by learned counsel for both sides, I have also perused his diary. Considering the materials available in the case diary, it is seen that some incriminating materials are brought against the present petitioner. However, it is seen that the accused petitioner is in custody since last 64 days, and thus the IO found sufficient opportunity to interrogate him, keeping him in custody. So considering all these aspects of the case, materials in the case diary, this court is of opinion that further custodial interrogation may not be necessary for the purpose of investigation. In view of this, the petitioner is allowed to go on bail for rupees 20,000, which once YouTube tag amount to the satisfaction of learned CGM. Okay, we're done.
Halil.
What is the question?
CD is not there.
CD not received.
Not none appears.
No, none appear.
Yes.
What is the question? Interim
CD
was
not received, my lord, on interim.
CD not received. CD not received. Issue reminder.
So not DQ.
No, CD not received. None appears. None appears on call for the petitioner. CD not received.
Aspect.
CD not received. Issue reminder. let the matter be accordingly listed in 2nd of June.
Some cases are fixed on second. Fifth, madam.
Fifth, 5, 6. Interim be continued, released in next.
18 minus seated, madam.
Are they on interim earlier?
Yes.
You were on interim?
Yes, Lord.
We are extending your interim for 15 days so
Lord,
that you can appear with
interim
a.
order was extended on 9/2/2026. Thereafter, the petitioner appeared before the IO, Lord.
I can understand. So they have appeared, they have cooperated
Yes,
for
Lord.
you. So that's why we are extending your interim up to 15 days so that you can appear before the learned trial court below with a regular application. For
Yes, Lord.
Okay. Yes, you are MS.
P. Soria.
Heard MSP Sohoria, the learned for the petitioner. So heard Mr. MP Goswami, the learned petitioner PP, appearing on behalf of state respondent. Next para, it is submitted by Mr. Goswami that the case has already been charged by CS number, yes?
CS number, my lord, 613/25, dated 15/11/25.
Be submitted by CS number 613/2025, dated 15/11/2025. 25 post. In this regard, Ms. MS Sohoria submitted that the petitioner had already cooperated in the investigation and their statements were also recorded. Next para, as the case has already been charge sheeted, the petitioner is hereby directed to appear before the learned trial court below with a regular application for bail, which may be considered in accordance with law, and till 15 days from the date of order, the interim be extended so that he can appear and pray for regular bail. The above observation, the present anticipatory bail stands disposed.
May I please, Your Lordship? The accused is already on interim mail, my lord. So accused has he has been directed on 11/3/26 to appear before the IO within 7 days. And I, along with the accused person, we have already appeared before he has already appeared before the IO. And his statement has already been accorded.
Lordship, I have received the CD, but it needs to be updated, Lordship. The statement of the victim is not, of the petitioner, Lordship, is not in the case study. They are already on interim, Lordship, so a date may be fixed.
My lord,
your interim was granted on 11/3.
My lord.
But your case CD is updated till when?
Interim may be actually.
In the month of March, Lordship. It's updated, it's up to date, Lordship, but the statement is not in the CD. There is a note that he has appeared, but I have not found the statement.
But note is there. Statement is not there.
Yes.
So, my lord, bail may be made actually because I am co-parting with the investigating agency, my lord.
Borua. Heard Mr. Saikian.
Mr. Dear Saikian.
Dear Saikian. Heard Mr. Dear Saikian.
Assisted by PP Saikian.
Petitioner and also Mr. P. Sharma, the learned petitioner PP, appearing on behalf of state respondent. It is submitted by Mr. Sharma that CD received, but the statement of the petitioner is not available in the case record, though there is a note of the IO that he appeared before the IO after obtaining the order of interim pre-arrest. Next, in that context, Mr. Saikia, the learned counsel for the petitioner, submitted that as per his instructions, he already appeared and his statement is also recorded by the IO. In view of this, later updated case diary be called for, directing the IO to furnish the statement of the accused petitioner along with the case diary if already recorded. And further, if it is not recorded, the petitioner is hereby asked to appear before the IO within 7 days so that his statement can be recorded by the IO and can send the case diary. Let the, when it can be?
In the month of June.
3rd of June. Let the matter be accordingly listed on 3rd of June. Proceed. What I'm going that your statement is not available in the case diary. Though you have stated that you appeared and submitted, but yes, note is there that you
My lord.
appeared, but statement is not available. That's why
Right.
if it is recorded, then we are asked the IO to submit the or to furnish the statement.
My lord.
And if not recorded, then you are directed to appear before the IO to record your statement. That much.
My lord,
We'll list it in fees.
on that very part, my lord, my submission is on that very particular day, I accompanied with the accused person and he appeared before the IO. His statement has already been accorded. What more is required, my lord?
No, I
Already
think
recorded.
we don't know. We are not available in the case diary.
But there
That
is
is your submission is
Mine.
okay, and your
Mine,
petitioner appeared. That is also there because
Mine.
note is there, but
Mine.
statements are not available.
my lord,
That's what I'm saying. Otherwise, you appear. There's no doubt
Mine.
about
Mine.
it, but your statement is not there.
24 Lordship CD has been received. It will be after a few minutes. You are just going to. Just after a few minutes.
After statement.
Here Lordship CD is scan copy.
Scan copy was called for, I think.
Scan copy.
Yes, Lord.
You have to go through Lordship. We have-
What is the case is that, Lordship? On earlier occasion, bail petition was filed by this petitioner along with two other petitioners. That is one Momina Begum and Abu Sahed. In that, that bail petition was finally disposed on 13th of February 26. On the basis that it was informed that charge sheet has been laid. And that Momina Begum and Abu Sahed was on interim. Therefore, they are directed, they are given 15 days time to file application this for regular bail. And in that case, Lordship, it is page 32.
No, it's
Lordship.
okay. Now he needs some time.
Yes. We'll go through Lordship right now.
You want to go to?
We'll go.
No, no. In this time or what you want?
Today itself, we can go through.
No. You're going to go?
Yes.
Okay, we're timing it is
Yes,
kept. It is kept for timing.
Lordship.
It needs some time.
Yes,
See.
Lord.
When 27 Lordship petitioner is an interim, and Lordship, we are asked to furnish a report as to if any case has been registered against them in Bagbor PS. We have received the report, Lordship. No case has been registered against the petitioner.
Interim was there, I think, earlier.
Yes.
None 77, none appears on call for the petition. Heard Mr. B. Sharma, the learned additional PP appearing on behalf of said respondent. And it is submitted. The report is already received from which police station?
Bagbor.
Bagbor. Received from Bagbor police station. And it is reported that no case has been registered against the present petition. In view of this, the present anticipatory bail petition is disposed of, and the order of interim granted to the petitioner on 7/4/2026 is hereby stands vacated. However, the petitioner will be at liberty to approach the appropriate forum in the event of registering any case against him. The FS report is thus kindly give us the report.
Yes, Lordship. I'll get a printout and
Okay.
furnish it.
The report received from the police station be kept as a part of the record. With the above observation, the present interlocutory application Anticipatory bail application is hereby disposed.
28 Lordship, the report was called for Lordship, it has not been received,
Report not yet received.
not received
Okay. It has to come from which place?
from
Borpeta
Borpeta
Sadar.
Sadar Lordship.
Borpeta Sadar.
Sadar.
You are Mr. Sikdar?
J.A. Sikdar.
J.A.
J.A. Sikdar.
You are not A.R.
No, no, Lordship.
Your
A.R.
name is
Sikdar is the
not here.
senior Lordship.
Name is not here. Are Mr. J.R. Sikdar appearing on behalf of Mr. A.R. Sikdar, learned counsel for the petitioner, and also heard Mr. B. Sharma, the learned additional PP appearing on behalf of state respondent. It is submitted by Mr. Sharma that report not received from Kolkata Sadar Police Station. In view of this, a reminder be issued. Reminder be issued to Kolkata Sadar Police Station. Full stop. Yes, when it can be listed.
Any date, Lordship.
A report on Nikolai.
Lordship.
List on 25. Interim be continued till next date of list.
Obliged Lordship. Lordship, well, Lordship. In 27, I'm there, Lordship. 27 Lordship. Just order
Because Lordship, no.
Oh, it is disposed of.
Yes, Lordship. But some observation may be made, Lordship. Because police is still searching the
So
petitioner.
what to do? There is no case. What to do now? You were on
There is no
interim.
case.
We extended your interim. No case is there. Now we cannot do it. Like, a blanket anticipatory bail cannot be given to you. There's for longer period for 2-3 years. You will be under protection. That cannot be.
Yes, Lordship.
That cannot be. Okay, it is disposed of. Blanket order cannot be given for 2-3 years again.
Wait, Your Lordship. I'm appearing in item number
People.
31, Your Lordship.
Huh?
I'm appearing in 31.
Yeah, Lordship, there
CD
are
was-
on interim Lordship, CD has not been received, item 31.
Not received.
CD not received, they are already on interim Lordship.
Say do not receive. Issue reminder. Yes, give a date in month of June only.
June, Lordship.
3rd June, Your Lordship.
Right.
If it is
3rd June.
convenient. Yes.
4th of June, Lordship.
4th. 4th of June. Interim be continued till next date. No, this one is 31 is with 32.
Yes, Your Lordship.
Who is in 32?
32 also interim is there. Both are in.
32. You are appearing on 32 also, no?
No.
32 to who?
32 is.
32 will actually talk. Done. 30.
32 council is different.
But there.
Yes, Mr.
CD
T.
was called
Talukdar
for,
was
I
there.
Let it be the same.
32 was separate corridor. None appears on call for the petitioner. Heard Mr. B. Sharma, the learned additional PP appearing on behalf of state respondent. And it is submitted that CD not received. No, not respondent quoted the post. CD not received, issue reminder. List the matter accordingly on 4/6/2026. Interim be continued till next date. Out of the one.
Yes, Your Lordship.
Yes, what is the position of 33?
33 Lordship, we have received the report.
Report received.
Yes.
Yes, what is the report?
Yes, Lordship. Here, Lordship.
But what they are making inquiry some.
Yes, they are making inquiry.
And they, on that basis, one GD entry is also made.
Yes,
But till now, no case has been registered.
yes, that is the instruction.
Then what to do?
My lord, I'm paying for interim, my lord. Till the date they register the case.
Yes, Sharma.
Also, I will have to take additional instruction also whether the case has been registered because inquiry is done and obviously also there is some offense has been
Because now
committed.
see that complaint or the inquiry was made on the basis of a complaint on 9/4/2026.
Yes,
And today we are in the month of May.
May, yes.
Then what to do?
Let them appeal also. Let them participate
My
in
lord,
the
kindly,
inquiry.
kindly
then,
allow
okay.
interim.
Because
my lord.
otherwise there's no FIR has been, it has not been registered as such. Only inquiry has been done.
My lord,
So
police
now what
unnecessarily
to do?
harass the
This
petitioner.
APE
my
would
lord.
be continued or I want to close it or what? Because I
What
don't know.
date may be given, Lordship, because I'm not sure, Lordship, what is this present situation. If case has been registered, I will take instruction, Lordship. One more date may be given, Lordship.
Pardon?
One more date may be given, Lordship. I'll take the additional instruction, Lordship, because obviously, Lordship, it's a month of April.
Huh.
Till date, they have not stated that they have registered the case.
No.
I don't
That's
know. Mutually, sometimes, Lordship, both the parties are asked to appear before the IO also. Then also it is tried to be settled there also, Lordship.
But they are not on interim.
Yes, they are not the interim.
They are not. So difficulty maybe on their part also to appear before
Yes.
the IO. So what do you suggest? Should they be
Yes,
on interim?
let them appear before the IO. Lordship.
My lord, kindly grant an interim. my
You
lord.
are Mr. Abbasi?
They are bus, madam.
Heard Mr. J. Abbasi, the learned counsel for the petition. Also heard Mr. P. Sharma, the learned additional PP, appearing on behalf of state respondent. A report is received from next full stop. A report is received from Parasil Ambari PS, wherefrom it is seen that one inquiry was made on the basis of a complaint made by one.
My lord, one is Bashford and one is Sanjeev
by
Chakraborty.
one Moromi Rapa in the police station. And accordingly one GD entry is also made. But till that there is no registration of case against the present petitions. In view of this court is of opinion that one opportunity may be given to the present petitioner to appear before the IO and to cooperate in the inquiry of this case. In view of this, as an interim, the police from Parasil Ambari PS is hereby directed not to take any coercive action against the present petitioner till receipt of the report. Stop. Next para. Further, the additional PP is hereby asked to take a call for a detailed report whether any case has been registered against the present petition. Let the matter be accordingly listed on 26/2000.
Highly objects.
May I please, Your Lordship, in item 32, there is an interim order. Earlier item.
Continue.
Honorable, no?
But it was a revision petition against the order of which order?
And learned executive magistrate, that is page 21 and 22.
Oh, it is against the executive magistrate.
Yes, attachment, yes, there is sufficient wrong. Because I am in the land since 18 years.
2017, the order. Is there any subsequently, is there any civil suit? No, instituted between the parties? Is there
That
any-
idea I do not have at
Do you
present.
have
No
any
civil
idea?
suit, Lordship.
No civil suit.
No civil suit.
And that will be maybe difficult because we are also not in a position to say anything whether the person still alive, not
Yes,
alive,
yes.
whether case is
At that time,
You have not contact since when?
actually, this was brought some lawyer. This lawyer, I will take his information.
It was listed on 21, 5/4/21.
Yeah.
Thereafter, Also, it is not listed. And it reveals that from if you go by the order sheet, on 11/1/2017, you were there, you are present on first order. And thereafter, what had happened on 13/5/2020, none appears.
None appears.
Then again on 26/5/2020, none appears. And again on 5/4/2021, none appears, and due to paucity, it could not be taken up. So that is the position that after obtaining the order on 2017, thereafter, I don't know. Do you have any idea want to submit anything? Because he has no contact with his client most probably for since how many years do you have? Since when you do not have any contact with your client?
Since the very beginning, because the lawyer gave me the file. So the lawyer,
No, you appeared on the first date. On 11/1/2017, heard Mr. M.U. Mamun, you appeared on the first day.
yes.
Then I don't know that after, I don't know.
I think it would be better you will also kindly fix a short date. Let us check the latest news and thereafter we will argue the case.
Okay, will do.
And Lordship, LCR not received.
LCR not
LCR
received.
not received.
Oh, that is also not received.
That's it.
Okay, we'll give instruction to the registry for calling the LCR that may be required. And you also take some instructions.
I shall try. I shall try.
And because it is an executive order, so the existence of the order is at present is also doubtful.
Doubtful.
Because 17 order, I don't know what is the position. So just take instruction and position of the land, if it is either maybe your position under his position, also maybe there are own person. Just take instruction with this. Heard Mr. M.U. Mahmood, the learned counsel for the petitioner. And also heard you are Mr.
A.U. Ahmed on behalf of K. Bhattacharya.
A.U. Ahmed appearing on behalf of Mr. K. Bhattacharya for the respond number 2.
1 and
Also, what?
1 and 2.
1 and 2, yes, 1 and 2. Next, it is submitted by Mr. Mahmood that since last many years after, since last 2018 মানৰ পৰা হ'ব নেকি? Since last 2018/19, he has no contact with the petitioner, and at present he is also not in a position to say as to whether the petitioner is still alive or the position of the or the land under whose position, or about the land in question. In the same time, Mr. So the learned counsel appearing for the petitioner, respond number 1 and 2 also submitted that the record TCR is also not received, which will be required to go for the argument. In view of this, the registry is hereby directed to take necessary steps in calling the record from the concerned court. And in the same time, Mr. Mahmood, the learned counsel for the petitioner, will also take necessary instructions or necessary instruction in this regard. Let the matter be accordingly listed. Do not affect 30th. 1st of June. Just take the instruction.
Okay.
We may get the case record also. We'll see. 160. Hey, very formula.
Process 5. Your lordship may take it up on some other day, your lordship. 5, this item.
5.
Lordship, I need some accommodation today. I could not prepare, your lordship. If
You
it
are
can
for
be
the
taken up on
respondent.
2nd of June, your lordship. Otherwise, it is ready for disposal, your lordship. Affidavit may apply.
You are appearing as a common advocate.
Yes.
Mr. S. Bhattakur, the learned counsel for the applicant petitioner, and also heard. You are MS?
D protest.
He protester, common advocate for the respondent. However, at the request made by Mr. Bhattakur, the matter is adjourned today.
On 2nd of June, your lordship.
List accordingly on the 2nd of June. Listing it on 2nd of June.
Lordship.
argument may be heard on that.
Lord.
Deeply obliged.
Yeah, please. This is an appeal against the judgment. Service has been completed, madam. And they were duly. My lord? No, already dispose of it. No repetition. Yes, madam. Six. Or
51 is
criminal leave petition, your lordship. This is an appeal against the equital judgment, your lordship.
criminal leave petition is the leave.
Yes, ma'am.
It's pending, still pending.
Yes, pending. Yes, sorry, my lord. I have the in the
It was the contradiction was there.
condemnation has been admitted, your lordship. Condone, your lordship, already. Condemnation order was passed on 11/8/2025, your lordship, on IA criminal. Yes, my lord. In IA number 1184, 2025. Notice phase service has been completed, your lordship.
Where from? You appeal.
Yes, my lord. Appeal, IA and leave petition we have served together, your lordship. Hand to hand, we have served the copy, your lordship. Gotcha.
No. Yes. 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 Not heard, but they have to first notice will be issued, lordship, in the litigation. Notice.
No, notice, my lord. I have copy served hard copy.
That is not.
Why not notice your lordship? Step লৈছো হেৰি আইৰ কাৰণে অলৰেডি তেওঁলোকে এপিয়াৰ হৈছিলে কণ্ডম হৈ গ'ল তাৰপিছত লিভ পিটিশ্যন আমি হেণ্ড কপি দিছিলোঁ তেওঁলোকক
What they are stating lordship in the IA, in the delay condonation petition lordship, already notice was served and they had appeared.
yes
Can I tell us the name? Yes.
yes my lord
Who
M
is it?
I have number also your lordship Imran Hussain your lordship
Imran Hussain.
is that possible
Third Khan. Who is third Khan?
oh R Khan is the junior of the Imran Hussain your lordship lady advocate your lordship.
So lordship,
I guess.
yes,
Okay.
yes, yes. They will have to appear.
Then my lord, order maybe pass I will take I will take a step then your lordship.
We direct this.
Yes, let,
Yes, my
let
lord.
their name be shown.
They may.
Yes.
They may.
Yes.
They have.
Yeah, he can also approach them lordship in the meantime.
Okay.
Lordship.
Okay. Then in leave petition, first time we have to take leave. Yes. Okay. Okay. Without leave. Yes, Islam.
I to one.
Am I Rahman? No, sorry. Am I Hussein? Am I Hussein? Well, the date may be fixed. Last of June. Last of June. Last of June. Last of June. Last of. Highly obliged.
May it please your lordship. My lord, the first is criminal petition 237. I have filed an application for Jimma, which was rejected. So I am before your lordship. My lord.
Yes.
My lord, in
in 237, my lord, one motor vehicle, Mahindra Scorpio, my iPhone, and my account was freezed of the bank account. So I am before your lordship. The rejection order is at page 16. As regards my lord, mobile phone and Mahindra Scorpio, I rely on that Ambala judgment. My lord, 2000 A 2003 Supreme Court 638. And as regards my lord, the freezing of my bank account after seizing and freezing, my lord, 3 judgments I have relied upon. It was already there in the record, my lord. One of a high court.
Criminal petition for Jima of your vehicle and mobile.
Vehicle, mobile, and my bank account. Your lordship may look into
Reprinting of your bank.
my lord.
Then what is the item number?
19 of another person who's same thing. Same. The issue is same, only in that I think Innova is there. Here Scorpio, mobile phone, and bank account is there. 3 judgments I have given as regards my bank account, my lord. One is 22.6 GLR page 772. Another is, my lord, 24.7 SCC page 23 para 11, para 23, 24, 26, 27, 28. And my lord, another judgment that is yet to be reported of 2025. My lord, in the record, the judgment copies are there, my lord. First, 2022 6 GLR page 772. 22 6 GLR 772 para 8. Para 8. Then, my lord, 24/7 SCC page 23. 7 SCC page 23. From para 23 to 28. Para 23 to 28. And my lord, another judgment copy is there, which is yet to be reported. Judgment was delivered in, my lord, 10th December 2025, where I relied on para 11. The state of West Bengal versus Anil Kumar De. The judgment copy is there. Para 11. 10 December 2025. I think, my lord, if your lordship just look into the records are there.
In that case, we were relying on
Para 11, which has relied upon 24/7 SCC page 23. The whole issue is this, my lord. As regards seizing and freezing, earlier 102 and 106 has to be complied with, but the word in that section is forthwith. These 2 judgments, 24 SCC and this 25 judgment, has said that forthwith the delay has to be explained by the IO or the police officer. Why, before sending the magistrate, if there is a delay, that has to be explained. For that, it will not vitiate the freezing of the account, but some action has to be taken against the police officer if there is a delay and the explanation of the delay is not there. But that has to be sent to the magistrate. And the Ambala judgment, my lord, as regards for vehicle and iPhone, AIR 2003 Supreme Court 638, para 7 and 21. 3 Supreme Court 638, para 7 and 21. Where it was said that within 15 days, regarding the vehicle and iPhone, that has to be returned by. That is Ambala judgment, my lord. Sundar Bhai Ambala Desai. That is my whole contention, my lord, whether before freezing, seizing and freezing, whether that has been complied with. Earlier 102 and subsequently 106. And as regards vehicle and iPhone, they had to provide it return back to me. They cannot keep it for indefinite period.
So what is your, whether those were complied?
My lord?
And then those were not complied.
Not complied with. This, as regard seizing and freezing, I think, my lord, 102 and 106.
Seizing, what about freezing? Yeah, sorry, freezing.
Freezing, my lord, they have not complied with that. And there is a delay. If there is a delay in, that has to be explained. That has not also been explained.
Matter was well from 48 was.
My lord, the order of the magistrate is 12/1/2026, and the FIR is at page, FIR is of page 28/11/25. FIR dated 28/11/25, and the rejection order of the magistrate is 12/1/26.
Rejection is okay. Rejection order of
That can be from the record only, my lord. That has to be seen from the record, whether they have complied that 106 or not.
you have not seen the record.
My lord, I have not, the record is with them, CD is with them. My lord.
From where you're coming?
My lord, because they have not complied with, the CD is with them because still investigation is going on.
What you're saying?
That has not been complied with, what I can understand. My lord. Your lordship may look into the CD, whether they have, if they have complied with, if they have complied, it is okay, my lord. But whether this explanation is there or not, I'm pressing that legal proposition as regards the seizing and freezing, my lord. Whether they have done it or not, that my friend can only submit.
Regarding it was passed on time.
That, my lord, order of freezing. Seizure list is, my lord, dated 1/12/25, my lord, as from the seizure list is at page 15. 15, my lord. 14 is a type copy. Date of seizure is 30/11/25. 30/11/25. Page 14. FIR 28/11/25, seizure 30/11/25. My lord, registered, the FIR is registered under section 368, 318, 316, 435 of BNS. 318, 316. 318.4, it will be followed. IPC.
That I'm searching Lordship. That I'm searching Lordship, that I have not gone through to that extent Lordship.
Therefore, it will account for that petition is moved.
That part I can see Lordship, that Lordship we can fix it that day after tomorrow, then Lordship that part I can see out there. I clarify Lordship whether it was done or not. That part was compared with section 102 was compared with not Lordship, because that submission has come there only, so we are not aware about that submission.
No, it was earlier also submitted because the judgments are there.
Probably other our council was there. Day after tomorrow, Lordship can fix it Lordship, that I can clarify. And regarding that vehicle also, probably that can be the release for the vehicle and mobile phone, that is the I think. But also that only that amount freezing of amount also. Even I have not found that even in the petition also how much money was there that has been freezed.
Yeah.
That is.
So, it only that
I have to take instructions.
For the petition, the council, the number was
That I will take instruction as well as I will go through the city also. Day after tomorrow. Anything convenient with the
No.
Arrow.
city.
Always.
Regarding that part also 102 compare it or not also when it was seized, when it was how much money it is. Some notes are there, and then I notes are there that they could not produce any or produce any documents regarding their source of income because they are only source.
Yeah, please. Yeah, FIR at page number, I'm on interim, my lord, and as per instruction, I have appeared, my lord, on 29th of April, my lord. Page number 9 is the FIR, my lord. Only non-available section is section 69, my lord. May I read that? The informant begged to state that since last 10/10/22, the above named accused person, after knowing me, had promised to marry me as he loves me. On last 5/4/25, the accused person took me to Gauhati by falsely saying that he would marry me and establish physical relationship with me, and about 3 months by keeping me in a rented room at Ambari, Gauhati. Later on 25/5/25, he got transferred to Jirkiding police station, West Karbi Anglong, and kept me in the quarter of the Jirkiding police station for about 7 months, where he cohabited and established physical relationship with me. And thereafter, whenever I used to ask him to get married or solemnize court marriage, the accused person used to threaten and assault me in the quarter of the police station. The accused person injured me by assaulting me on last 6/9/25 at about 2 p.m. and 8:30 p.m. in the night. On 19/9/25 at 12, he broke the door of my room and injured me by assaulting. On last 29/9/25, the family members of the accused person came and verbally abused me by using bad language and destroyed the articles of my room. And the accused person has also assaulted me. My lord, I am a sub-inspector of police, my lord. Now, initially, my lord, we were in love, my lord. Accordingly, we have informed both the families, my lord, and we have started prohibited with each other, my lord. And the FIR also transferred the same. I have not kept her hiding anywhere, my lord. In the police station, my lord, in my service quarter, my lord. Because in our tradition, my lord, there is no formal marriage is performed, my lord. We have to inform both the families, my lord. Accordingly, we did, my lord, and we started to live with each other, my lord. Later on, some differences arose, my lord, because she wanted to have a reception, my lord, of our marriage, my lord. But due to some frequent transfers, my lord, I was unable to. Actually, my lord, the position is, my lord, it's not, my lord, because the families are also not wanting, my lord, to be with us, my lord, together, my lord. So,
but there may be some occasions, some reasons due to differences he
yes, ma'am.
or after under the instruction of some other person,
Yes,
so he might have lost the FIR. So if your relationship is still there, then you can continue, or the other marital formalities what are there.
Yes,
left
ma'am.
behind that can be possible.
Because we have to sit together for that, my lord. And because of this case, my lord, my lord.
There are some.
Yes, ma'am. In fact, my lord, the informant has also filed a, my lord, objection, where everything has been admitted, my lord. What I am, she has supported my version only, my lord. After, my lord.
Absolutely not.
My lord.
I have not supported the version of the.
My lord, kindly come to my lord. Because after, my lord, some ceremony was held, my lord, as per her, my lord. And thereafter, we started to live together, my lord.
Yes, because
So
after
what
the
I have
ceremony.
submitted, it is, my lord. So, my lord, due to mental differences.
Okay, okay, I'll get to you. Yes, Mr. Gustami.
Lordship, here, my lord, if I go to the statement first of the accused person, my lord, there is no denial the fact that she is not her wife, my lord.
Yes.
As per his version, my lord, they have eloped together, and after that, she used to stay with her for several months, my lord. And after that,
Yes, in the official quarter also.
yes, quarter also, and that she is in the quarter, my lord, that has been, my lord, authenticated by the other witnesses of the police personnel, my lord. They said that what they say, my lord, that yes, for some days, my lord, some months, everything is okay. But thereafter, quarrel started between them, and the lady, my lord, victim has reported to them that the accused person used to beat her, my lord. And that report has also been, my lord, that has also been conveyed to the superior officers, my lord. That is the position regarding that, my lord. And thereafter, my lord, as per, but the second part of the, my lord, statement of the accused says that, my lord, they have demanded money to him and he has not fulfilled, my lord. That is 1/3, my lord. and the mother of the victim has taken herself from the custody of the accused person, my lord. And that is the
And now
case,
demanding money.
now demanding money, my lord. And since he had not, he said that he has also given money to, he has also given money like 2 lakhs, 1,50,000. These are all things that he has given money, my lord, that to the father-in-law and other brother-in-laws, my lord. But in the later part, he said that since there is quarrel between them, that the mother came and took the victim away from him, my lord. But in his statement, he said that we are together as husband and wife, as home at Boithalangsu, and did the rituals in the presence of Gaubura regarding marriage matter. And the witnesses, as I have stated, my lord, it's stated that she came to them, to the other police personnel, my lord, that the accused used to assault her regarding the quarrel between them. That is by the given stated by the accused witnesses, my lord, regarding the assault. They are also police personnel, my lord, and he has given a long 183 statement, my lord, 4 or 5 pages, my lord. But he stated, my lord, just I am reading the relevant part, my lord. থাকোতে আমাৰ মাজত শাৰীৰিক সম্পৰ্ক হৈছিল কোৱাৰ্টাৰখনত ভালে ভালে থাকিলো, কিন্তু কেইদিনমান ভালে ভালে থাকিলো, কিন্তু এদিন ৰাজুৰ মা ভিনী আৰু তাৰ মাজু বাইদেউ আহি নজনাকৈ কোৱাৰ্টাৰত আহে আৰু বয় বস্তু খেলি মেলি কৰি দিয়ে। ৰাজুৱে ৰাজুৰ মাক বায়েকে অশ্লীল ভাষাৰে গালি গালাজ পাৰে আৰু মোক ওলাই যাবলৈ কয়। সেইদিনাৰ পৰাই ৰাজুৱে মোৰ ওপৰত মানসিক আৰু শাৰীৰিক অত্যাচাৰ আৰম্ভ কৰে। Thereafter, everything came. Yes. But kindly, I'll submit the CD, looking at therefore. Okay. And the medical.
Yes,
I have also
Mr. Bora,
like
what
marked the
you-
medical and let me what he has to say, my lord.
Actually, it is not a case of the petitioner that it's a failed relationship. From the very first inception, Lordship, the petitioner received the complaint. It is not disputed that they were not in love. They were in love. An engagement ceremony has taken place at page 25 of my affidavit. I have submitted that photograph of that ceremony, Lordship. That ceremony had taken place. That engagement ceremony had taken place, and that is prior to the joining of the petitioner at Fotakilambari. He visited the residence of the petitioner complainant, and therein, Lordship, the engagement had taken place. And then there was a promise from the side of the petitioner that they will marry. A formal marriage will take place, because they say, the petitioner say in their petition that there is no formal marriage required in Karbi custom. It is absolutely false. There are 7 steps in Karbi customary law to get a proper marriage. In Gauhati, they stayed together from April to June. Thereafter, he was transferred to West Karbi Anglong. The complainant's father is a sub-inspector who is serving at Hamren. He received and picked up the petitioner from Hojai, and then this petitioner stayed at Hamren Police and then Hamren Police Reserve, and then he was posted at Ziriginding PS. At Ziriginding PS, the petitioner, since there was a promise to marriage, and since then an engagement ceremony had already taken place, both of them, they stayed at a quarter of Ziriginding PS. At Ziriginding PS, what my learned PP has already submitted, at Ziriginding PS, while they were staying together, the family members of the petitioner came there, and then they assaulted. And thereafter, Lordship, the petitioner was posted at Kharani police station. At Kharani police station, this petitioner, he blocked the phone number of the complainant. And then the complainant, she completed her B.Ed degree at Kharani, B.Ed college, Kharani, and then she went to the Kharani police station. She tried to lodge a complaint. The officer in charge of the concerned officer in charge of Kharani police station, he advised that you do not lodge a complaint, otherwise there will be problem in the services of the petitioner. And then she did not lodge a complaint. And then he unblocked the phone number of the complainant. And after 2 months, again he did the same thing. The complainant has been repeatedly asking the petitioner to get a formal marriage first and then a marriage reception, both and including a registration of marriage, because it will be required in his service book for record. That has been repeatedly denied by the petitioner, showing one and another reasons. And therefore there was a delay in lodging the FIR. In fact, it was on the instruction of then SP Bolinduri. I have categorically mentioned in my affidavit in paragraph number 3, 4, and 5. It was on the advice of Bolinduri, they did not lodge the FIR. The moment Bolinduri got transferred, the petitioner denied to marry her. Because when Bolinduri advised, the then SP advised, the petitioner promised that within 1 month I will get the marriage registered. And the moment he got transferred, he had shown his true colors, and then on 1st of March, he got the transfer order and he had joined at South Salmana. And from then, Lordship, this is what is going on. Now the petitioner doesn't want to get the marriage registered, though he is saying that he treats her as his wife, but that is not the in true sense.
So saying that if there is a both of them stay together as a husband and wife, if he thinks that, or if it he considers her to be his wife, then obviously the misunderstandings should be avoided, and there has to be some ceremonial thing that's spoken, both the parties can live
Yes.
together again. So that can be there.
Yes, now the entire
Can,
family.
you can talk to your parents also,
Yes, yes.
because now the case, if you suppose bail is granted, not granted, that is another aspect. But the question is that case is already registered against you.
Yes, ma'am.
So that will again may create some
Yes.
problem in your career also.
Yes, ma'am. Definitely, ma'am. Definitely.
Their incriminating materials are also now selected by the
Yes,
No,
yes.
my lord.
witnesses and also 183 statements.
Mm.
Also, that yes, there is some quarrel between them, and assault is also a part of that. So,
And for that assault, he was reserved close,
Mm.
the petitioner.
Reserve clause.
Yes. He was given the punishment of reserve clause for some time.
it's police
Oh,
department.
acha, police.
Yes. In fact, now a show cause has been issued in which he has already submitted his reply
Yes, ma'am.
by the department. Departmental proceeding has been initiated. Probably.
On this complaint on.
Then obviously it will
Yes,
be
my
there
lord.
because
That
department.
will, I will face that, my lord.
Mm.
Yeah, that is another aspect, my lord. And at the inception, whether I had any intention, my lord, that has to be considered only, my lord. Because subsequently relation can go other way around, my lord, also. But at the inception, whether I was having any intention to not marrying her, my lord. No, my lord. In fact, a ceremony was conducted as per his version, my lord. I have stayed with her, my lord. I have kept her. And subsequently, my lord, in the statement also came some money was demanded by my mother-in-law, my lord. That all has, my lord, created some disturbance in our relationship, my lord. That is the problem. Apart from that, my lord, I have already appeared, my lord, whether my custody is required, my lord. And I have always introduced her as my wife to all the persons, my lord.
Okay, hard Mr.
And that is the difficulty, Lordship. The entire police
Yes.
administration in
Because
West Bengal
I was with
that
my
both
clean
of
hand,
them
my lord.
are husband and wife, and now the petitioner doesn't want to get the marriage registered.
Mm.
Or
Because of my
Uh,
frequent marriages, transfers, my lord. And he has also stated that I was under punishment posting, my lord.
You can give a reception to your department people
Yes,
and all. You
definitely,
can
ma'am.
the petitioner is a
My
resident
lord,
of
kindly see, my lord, on which
service
date,
people
my
are
lord,
there.
Yes.
on which date this FIR was lodged, my lord. On 1/3/2026, my lord, when I was again transferred, my lord. I have informed her that I got again transferred, my lord. This time FIR was lodged, my lord.
Both the complainant and the petitioner are resident of Karbi Anglong and West Karbi Anglong, the nearby two districts.
Because, my lord, some money is also required, my lord. That is the problem, my lord. That is the reason of our this
Set
heard
out
Mr.
relationship, man.
H. Ali,
Submitting
Delegate
the
Counsel for the-
case diary, my lord, for the
Yes.
lordship's proposal, my lord.
Heard Mr. H. Ali, Delegate Counsel for the petition. Also heard Mr. MP Goswami, Delegate Additional PP, appearing on behalf of said respondent, and Mr. P. Boda, Delegate. R. Boda, Delegate Counsel, appearing for the informant respondent. So this is an application, the section so and so in connection with so and so. Full stop. Next, madam. It is submitted by Mr. Ali that after obtaining the order of inventory arrest bail, he accordingly appeared before the IO, cooperated in the investigation, and his statement is also recorded. He further submitted that it is a it is a fact that the petition there was a love relationship between the petitioner and the victim, and in person to that, after having some rituals, they started living together as a husband and wife. He even took her to his official quarter wherein he introduced her to every official as his wife and but she was insisting him to go for some rituals, and as there was no rituals as per her choice, she started quarreling with her, and she also left his official quarter by her own after he got transferred to another place. Full stop. But he is another place, but he never hide his relationship with the victim, and she was rather considered as his wife and introduced her in before every officials as well as the other members of his family as his wife. Thus, there cannot be any reason for false for no. Does this section 69 and the other related section does not affect against him However, he is still ready and willing to extend his cooperation in the further investigation of this case if he is granted with the privilege of pre-arrest bail. Next, Mr. Usami, the learned additional PP submitted in this report that it is a fact that the victim also admitted their relationship, and it is also admitted that there was some rituals between them, but thereafter and they stayed together as a husband and wife. But in the official quarter, they lived together peacefully for some days, but thereafter they used to torture her both mentally and physically. But then no, torture her mentally. No, sorry. Torture her mentally, physically. But during that period, the mother and the other relatives of the accused came to their official residence and assaulted her and tortured her by throwing her all household goods. Full stop. Thereafter, the petitioner also started torturing her mentally and physically, and also tried to stop every relationship with her, and for which she had to institute present case. Next paragraph. Mr. Bora, the learned counsel appearing for the informant, also submitted that it is a fact that there was a relationship between both the parties, but from the very inception of their relationship, he had the intention to deceive her. It is an admitted fact that some rituals like engagement was taken place between them, but there was no formal marriage or registration of marriage between the petitioner and the victim till date. He further submitted that he subsequently tried to avoid her and also blocked her mobile number when she tried to when she was ready to file and lodge an FIR, but due to intervention of the SP concerned, she did not lodge any FIR and lodged any FIR, and thereafter the petitioner also unblocked his mobile numbers. But after he got transferred to Heroni police station, he stopped every relationship with her and thus deceived her and cheated her with the false promise of marriage. Mr. Bora accordingly submitted that it may not be effective to extend the privilege of pre-arrest bail to the present petitioner at this stage. Next para, hearing the submission made by learned counsel for both sides, I have also perused the case record and the case diary. Case diary post. From the on perusal of the record, case diary, seen that after obtaining the order of interim pre-arrest bail, the petitioner appeared and accordingly cooperated in the investigation, and his statement is also recorded by the eye. On perusal of the 183 statement of the victim, it is seen that both of them had the relationship with each other, and they also started living together as a husband and wife, and he also introduced her before his officials as his wife, but as submitted by as submitted by learned additional PP, thereafter some dispute arose between them, and there was differences between them. It is also alleged that she was subjected to mental and physical assault, which was reported to some of the witnesses, and who accordingly disposed it, who accordingly stated that they have heard from the victim that the petitioner used to torture her mentally and physically in the official quarter. Thus, there is seen that some incriminating materials has been brought against the present petitioner in her statement recorded under section 180 and 183 BNSS. However, it is seen that it cannot be denied that the present petitioner introduced her as his wife before the official colleagues as well as the other family members. Considering all these aspects of the matter, materials available in the case diary, and the cooperation extended by the present petitioner, this court is of opinion that further custodial interrogation may not be necessary for the purpose of investigation. And accordingly, I find it efficacious to extend the privilege of pre-arrest bail to the present petitioner, and order of interim pre-arrest bail dated 12/03/2026 is hereby made absolute with same terms and conditions. Your prayer made absolute, but from this court, it is out of record, I'm saying.
My lord.
Just try once to don't break up your relationship.
Yes.
Because it's a good couple years, seems to be happily residing.
My
Maybe for 2-3 months, but there was some relationship.
my lord.
So try to get it solved. Because it's not a case if you grant the bail also, but in that case also one case will be definitely against you. And as Mr. Bora has submitted that already you have received some show cause notice from your department also. So if that department proceeding also may initiate it against you, because these are the criminal offenses. So try to manage all these things. If you are happy, can decide happily with your
I have already
wife.
instructed him.
Because she was your wife or you treated her as a wife.
Yes.
If then obviously rituals may not be there, but try to get some rituals also so that
Yes.
function, minimal function is should be there. In that case, it may be some problem may be sorted out in that manner also. Because your family members and family members of the victim also, they were known to each other and they accepted your relationship.
Right.
That is no doubt
Yeah,
about
doubt
it.
about it.
That's why I'm saying.
Yes.
Try to get it.
Yes.
Okay.
Always. I live.
117(2), 118(2). So 191(1) is only definition clause of rioting, Lordship, and 191 subsection 2 is bailable. 329(3) is bailable. 117(2) is bailable, Lordship. 118(2), well, 118(2) is earlier 326, Lordship. There, life imprisonment is there. When there is life imprisonment, Lordship, there is, as per now, 480, Lordship. Earlier it was 437. Now 480 clause 1. There is an embargo, Lordship. There is an embargo that when any person accused of so-and-so, the High Court, Session Court, he may be released on bail, but such person shall not be so released if there appear reasonable grounds for believing that he has been guilty of an offense punishable with death or imprisonment for life. That embargo is there. So if we go to the magistrate, Lordship, when the charge sheet is being laid, so due to this embargo, we had reasonable apprehension that we may not be allowed bail. Lordship, in this context, Lordship, I would like to draw your honor's kind attention to my petition page number from page 48, Lordship. From page 48, it is a decision of the coordinate bench of this court, Lordship, specifically in page 50, Lordship. Page 50. Here also, it was a case of on earlier occasion, the session judge has rejected bail, and thereafter the charge sheet has been laid, and 304B, 20 and 34 of the Indian Penal Code. And in that case, in para 9, Lordship, para 9, it was observed. May I read, Lordship? Para 9, page 50. It appears that presently the PRC case number so-and-so is pending before the Court of Learned Judicial Magistrate First Class Nagaon, and same being Court of the Learned Judicial Magistrate First Class Nagaon, even if the petitioner surrenders before the said court. Due to the embargo of section 481(2) of the BNSS, he may not be granted bail, and therefore he apprehends that he may be remanded to custody. In view of this position, in para page 51, that the PAS bail was granted, Lordship, by this coordinate bench of this court. Here also what happened, Lordship, in prior to filing of my earlier bail application, the PRS bail of the petitioners were rejected by Sessions Court, additional session judge, which was annexed in page number 52 and 53. Now, when the charge sheet has been laid, when we went there, the other two petitioner has appeared and they are got bail. When we inquired about this, we found that this 118(2) is there, where there is an embargo. If I go directly to the magistrate, Lordship, I may not be allowed bail. So we are that apart, Lordship. I am just for your Lordship's just kind perusal, Lordship. I'd like to point out that we have already annexed the cross FIR here, Lordship, and page number 29 and 30, Lordship. Lordship may see page number 29 and 30. They are the injured person, Lordship, of our family who were earlier granted interim bail by this court, Lordship, among our family group. That apart, Lordship, the cross FIR is also, although it is not available here, we have inquired the matter. The cross FIR also, the police had filed this charge sheet, Lordship, and it was numbered as PRC case number 116/26. And in that case also, Lordship, same sections, including 118(2), is being charge sheeted, Lordship, against the other persons also, and that case is
As per the CIS inquiry, Lordship, that case is pending for appearance of the accused. So far, at this stage, my submission is that, Lordship, we are local men. We are, as because they have, in the search sheet, they are shown us as absconder. Although we are not absconding, we are filing a petition before the Sessions Court as well as before the High Court, Lordship. We are seeking legal relief. We are not absconding. We are local person. We will appear before the trial court, Lordship, and we may be granted PRS bail, and we will accordingly immediately appear before the and to assist the trial and to face the trial, Lordship. That is my humble submission.
I have gone for the TCL also. And the teacher, one thing is there also that medical report is not available. As there is a grievous heart section is there, that is not available. Mainly medical report is not available. But apart from that, also the statements of the complainant and the victim, they have stated that the FIR accused has assaulted us with the weapon. And they have also that witnesses part also will see also that witnesses have stated also they have heard that this person, all they have mentioned, all these persons have, these persons have assaulted this person. That much is there also. And
we will face trial. We will face trial.
Medical may not be there at this stage. We are not on that because case is already charged under 112. Merit, obviously merit may be there, may not be there.
The taking statement and the informant statement, they have also and they have stated like that. They have assaulted. And the witnesses
FIR named accused or they have named the person? No, not
FIR named. That's it. The witnesses have said that they have heard that these persons, all these persons have, they named those persons' name, but they have heard that this person has assaulted. That's not there.
We will face Lordship at any condition. We will appear before court. That's because both the cases are already being substituted, Lordship. The FIR and the
These 7 numbers of petitioners earlier appeared.
Lordship.
No, these you have now you are for 7 numbers of petitions.
Yes, Lordship.
So all the petitioners earlier filed any application?
Yes, Lordship. Yes, we have this enclosed here. We have enclosed here in page number 31, 32, and 33, Lordship. Your Lordship's order, Lordship.
There was altogether 9.
9. And out of that, 2 were given PRS bail, which photographs were I have shown, Lordship. They were injured, therefore they were on interim bail. And during that period, it was informed that CS has been submitted. Therefore, they were allowed 15 days time to appear before the court. So and by that time, it was also.
Order was sufficient, Lordship,
Yes.
Which may be Lordship may kindly come to the page 33.
Yes.
That from Lade trial court for their regular bail. That means these persons, Lordship. In the same case number 238/25 within a period of 15 days from today, which may be considered in accordance with law.
No, those petitioners are not here, Lordship. They have already appeared. They have already appeared and got bail. We are remaining who were not this. Yes. No. We had also applied, but in respect of all 9,
interim were not considered.
Interim were not given even, not given. Only 2 were given interim, Lordship. Thereafter, when the CD was called for, CS comes and that order was passed. So we are not given any direct, interim, Lordship, earlier, nor rejected by this court on merit.
Mr. Diula did not cost for the petition. The additional PP bring on behalf of state responsibilities and application under section 7. It is submitted by Mr. Ulla that the present accused petitioners along with 2 others were earlier applied for PRS bail before the learned session that was rejected, and thereafter they appeared before this court with a prayer for anticipatory bail. And during the pendency of the and considering the fact that 2 of the petitioners, namely Momina Begum and Abu Shayed, Abu Shahid was the injured person, and accordingly, considering their nature of considering that aspect, those two petitioners were provided with privilege of interim bail. But during the pendency of this anticipatory bail application, case was charge sheeted, and accordingly, by order dated 13/02/2026, this court had directed all the petitioners, including those two petitioners who were on interim pre-arrest bail, to appear before the learned trial court below within 15 days with a prayer for a regular bail application. The petitioners which were the accused persons which were earlier interim pre-arrest bail had already appeared before the IO and cooperated in the investigation, and for which they were not shown as an absconder in the charge sheet, but remaining petitioners, that is the petitioner number 1 to 7 in the present case, were shown as an absconder as they could not appear before the during investigation of this case. But they were never absconded, and rather they approached in 2 occasions, seeking anticipatory bail before the learned session judge as well as before this court. However, during the pendency of the bail application, as case has been charge sheeted, they did not get the opportunity to appear before the IO with a pre-arrest bail. However, all the petitioners are ready and willing to appear before the learned session judge and to contest the case. But the case has been charge sheeted. Case has been charge sheeted under section 191(2), 191(3), 329(3), 1172, 1182 PNS, and though the other sections are available, but section 1182 PNS is a non-available one, along with the non-available one where the imprisonment period may extended up to life, and thus if the petitioner surrenders before the court of before the learned trial court below, due to embargo of section 480 clause 1 bracket of 2 and small Roman 1 of PNS, the magistrate or the officer may not grant bail, and thus there is an apprehension of remanded to the custody. But remanded to the custody, and for that reason only, they could not even surrender before the learned trial court below with a prayer for regular bail application. In that context, he also cited order of coordinate bench of the court passed in AB number 1055 of 2025, dated 14/5/2025. Next, Mr. Ullah further submitted that there was a cross case between the parties, and as per his information, the cross case is also charge sheeted, which was registered as PRC case number 116 of 2026 under the same sections of law. Accordingly, he submitted that if the prayer for pre-arrest bail is considered at this stage, a petitioner can appear before the learned trial court below with a regular bail application. Next para, Mr. Lockhart, the learned additional PP submitted in this regard that case has already been charge sheeted, and these accused petitioners are shown as an absconder in the charge sheet, and that apart there are sufficient materials against a present petitioner who assaulted the victim, causing grievous injuries on their person. Mr. Rocker accordingly raised objection and submitted that they may surrender before the learned trial court below with a regular period. Next one, considering this submission made by learned counsel for proceedings, it is seen that admittedly there is cross cases between the parties, and two persons, oblique the accused person, who earlier granted with creator's bail, also sustained injury due to alleged assault made by the informant side. Further, it is seen that the further considering the submission made by Mr. Ulla, especially clause 4, especially section 480, clause 1, section 1, 2, Roman 2 of the BNSS. It cannot be denied that the probability of remanding the accused petitioners to jail hazard cannot be denied. By the learned trial magistrate. Considering this aspect of the big case and all other aspects, including the cross cases between the parties, and also the approach made by the petitioners before the court seeking pre-arrest bail, etc. This court is of opinion that the protection of pre-arrest bail may be provided with the petition. And in that event, so pre-arrest bail to DDBA with reply with a further direction to the accused petitioner to appear before the learned trial court below with a regular bail application, which may be considered in accordance. Your interim order. Next date is fixed on when?
Lordship. Lordship, I'm not here.
Okay, then. DTO আৰু direction DTO date to এটা নাজানো।
Within 1 week.
Within 1 week কৰি দিয়ক ন। Otherwise, you are granted with pre-arrest bail with a direction to appear before.
Yes.
But the question is that you have to submit bail. I mean, there is a confusion not exactly, but the anticipatory bail application is disposed of with a direction. You appear before the learned trial magistrate.
No, Lordship. This so far as us is concerned, their interim is there.
No. We are continuing in.
I say, so far as our is concerned, Lordship, when we inquired, then we found that the section initially, when on the day of the passing the order, only the charge sheet, the number of charge sheet is there. So we do not know under which.
No, we are not on that. I'm not on that. I have already granted you the pre-arrest bail.
Yes, Lord.
I have already granted you. Our question is that where to.
CJM, Lordship.
CJM.
CJM Nongam. Because it is
So
yes,
it will be satisfaction to CJM now.
to the CJM Nongam.
Separate bail to CJM Nongam দিয়ক আৰু surrender বা এনেকৈ দিব পাৰে। Bail and on his appearance will diok নহলে, and on their appearance before the learned trial court below, they will be allowed to go on bail for rupees 30,000 each with 1 COT black. Okay, then Lilanet CJM, you surrender. We anticipatory bail prayer is granted.
Obliged.
We are for the state lordship. Service report, negative lordship, so we will take test step. It's a about the delay. Regarding delay. Oh, acha, but yes. Can it date be after 4 weeks? After 4 weeks. Then order follow. What is it?
My lord, in this case, though some instruction was called for from my learned friend, my lord. But before that, my lord, I think my lord, it will be my lord, service on respondent number 3, my lord. It has not been completed, my lord.
Still awaited.
Still awaited, my lord. Yes, my lord. 24. It's a order dated, my lord, lordship will find. 23/4. Lordship.
Verification report is required.
Yes, ma'am. And it was called for from my learned friend, my lord.
So, what is the report you have not received now?
What has happened also? Pursuant to Gujarat police, bank account was frozen, closed.
Yes.
By the officer in charge of
Silchar police.
Now, Lordship, after that, Lordship, this petition was filed. Thereafter, Lordship, one communication was received by us that the Gujarat police said that the bank account can be defrauded. But the amount, which the suspected amount was there around 30,000, that has to be kept in lead. That was the observation. Then they have produced one communication in their additional affidavit. So regarding that, one verification was sought for by the court. But in the meantime, also, what has happened, if the concerned bank, that is the respondent number 3, if they can appear on it, then it will be very easier for the petitioner to replace the account. That is why also the service on respondent number 3 is out. Right? So they can take that step.
I'll take fresh step, my lord. That will be better.
Sir, look, okay, then they will take first step for the respond number 3. In the meantime, you also try to collect the verification report. If there is, suppose Gujarat police, as you have submitted, I have not gone through the record. But if the Gujarat police is on that view that apart from that 30,000, rest can be defreezed, then it's okay. Hard. You are Mr.
G-Uddin, lordship.
Heard Mr. G-Uddin, the learned counsel for the petition. And they also heard Mr. B. Sharma, the learned additional PP, appearing on behalf of state respondent. It is seen that the service for the respondent number 3 is still awaited, and accordingly, what to do? You are going to await for the service or want to take fresh?
I will take fresh step. Or I will check whether if there any standing counsel is there or not.
However, it is submitted by Mr. Uddin. He wants to take fresh steps in the respondent number 3. Respondent number 3 in view of this, let us speak press notice be issued to the respondent number 3 through speed post and usual process. In the meantime, the additional PP is hereby directed or hereby asked to seek the verification report of the letter dated 31/12/2025, stated to be written by Inspector of Police Bedi, B-E-D-I, Bedi Marine, M-A-R-I-N-E, Marine Police Station, Jamnagar, Gujarat. It is the matter according. You want any fixed date here?
My lord, some short date because this
Not very short. So I can
petitioner account is my lord pension account, man.
First week of June will do. First or second or third?
First week.
1st June. Okay. One. Okay, we're listing it on 1st week.
Right.
And in the meantime, you try to collect the verification. Or if you can communicate with any standing council of the bank authority or the response number 3, then you just make
Yes, yes.
so that they can appear.
My lord. All right.
Yes, what is 36?
Lordship,
We have received this scan copy here now.
Yes. Yes.
Service report on respondent number 2 appeared here. No,
Lordship, respondent on the last day, service was not complete on.
completed. No, it was awaited, but now what is the position?
Lordship, as per
851
the-
report is there on 85. Acha, refused.
Yes, Lordship.
Yes, Mr. Goswami, refused is there. Then can it be, who is respondent number 2 in fact?
Respondent number 2, Lordship, is the complainant before
Complainant.
the trial court.
So why he or she, I don't know, refused to accept the notice? Imran Hussain. As per the office note, you now see notice issued in post. Respondent number 2 has been received back answer with a postal remark refused. And the same is placed. So, in that case, it will be deemed to be served otherwise. And otherwise, we have received this scan copy, na?
Can copy it.
You are Mr.
As thus, Lordship. Lordship,
As that you are appearing for someone.
yes, Lordship, for SP Sharma.
SP Sharma. Heard Mr. S. Das appearing on behalf of Mr. SP Sharma, Daniel counsel for the petitioner, and also heard Mr. SP Daniel counsel appearing for the state respondent number 1. From the office note dated 8/5/2026, it is seen that that the notice return answer, remark, postal remark, inverted comma refused. RPS.
It's a complaint case. Taking without a complaint. Because
That is also another
it
issue.
is not a case, not a GR case.
So, though you are a party, but still is a complaint case.
It is a complaint case. We are a formal party that I have seen.
But it is it is case nature of cases.
Regarding the CR council.
No, CR means
It's a defamation.
Defamation case, Lordship.
defamation to his presence is required.
No.
Then say what to do. Refusal, though you it has to be deemed served.
If it is when you complain, then it is not a matter. It is a informant. But here it is a complaint.
Ah,
That is a difference.
X to course, like X. He refused. But yes, it is refused.
Refused.
Then what to do? His presence.
It's a hard.
It deems served. That's why, but Mr. Goswami is saying that it is a complaint case, so his presence is required. Otherwise, it would have been informal. Then the state is already there, so no issue. So you have to submit in that regard. Otherwise, what to do?
He may file in regarding that.
Why?
Regarding they have refused to.
No, it is returned to the court only. They are not supposed to file.
Enter notice to OC.
Okay, that can be one last aspect can be done.
Yes.
Because who put the signature, how it is returned, we are not in a position.
No.
Okay, then as does on behalf of so and so, and also had so and so. As per of this so and so, return answer. Refuse RTS. Return to area. Thus it can be deemed to be served on the respondent number 2. However, considering the nature of case, which is a complaint case, this court finds it justified to issue a fresh notice on the respondent number 2 through officer in charge of the concerned police station. Petitioner will take necessary steps within 2 or 3 days and list the matter accordingly.
Lordship, interim will be extended. There is an interim order, Lordship.
No.
Maybe
extra. Do not pass the quit 5th of June, so and so. Interim will continue till next day. What I'm saying, now see your this return answer with a postal that he refused. And refusal is always can be considered as a team service. Now, the question is, state is a party, maybe a formal party. Because defamation is exclusively for a personal thing, isn't it? So that's why for the avoid other contradictions, we thought that one more steps can be taken through officer in charge of the police. And in that case, even if he refuses, then it will go. Okay. So you take step within 2-3 days.
Okay. Much of
Lordship, I'm seeking an adjournment for the day due to my senior's personal difficulty appearing for you.
Who, Mr. R. Shekhar?
Yes. My lord, can it be fixed next week on Thursday?
Your name is dear? Your good name?
No.
Your good name, what is your name?
K. Borman.
Huh?
K. Borman.
K. Burman. Art Mr. K. Burman appearing on behalf of Mr. R. Shekhar, the learned counsel for the petitioner. Submitted that due to some personal inconvenience, he could not appear before the court to proceed with the hearing. In view of this, the matter is adjourned. Yes, 4th of June. The next week is not possible. 4th of June is a hearing day. We are fixing on that.
My lord.
4th of June, 4/6.
Obliged.
Yes, 41, Mr. Uddin.
Yes,
ready?
my lord. Yes, my lord. I please your lordship.
It's a criminal appeal, na?
Yes, my lord. Very short, my lord, because only 6 PW is what, out of 6, my lord, 3 is the my lord, main vital, other 3 is the IO.
Official.
Yes, official, and 1 is the important, other 2 is not important. So I will not take more time, my lord.
Okay.
In appeal, my lord, the page 15. So many, very short, I will help because so many occasions cases listed. And I also, my lord, I could not trace because my learned friend said that that both cases will be, my lord, I and appeal will be same time. So he is in jail, my lord. So many occasions, my lord.
No, we are ready, but what is yours from your side? I don't know.
I'm ready, my lord.
No, you are ready. I am ready. But they are from my guy just.
Because 37, I thought my 37
why?
taken up, my lord. That is why I've gone through the 37, but taking.
My lord, I will gone through the my lord, PW, my lord, shortly.
Just a second, Mr. Uddin. Just let them tell. Like he is saying that he will. I mean, the evidences are before you. So if you can, then otherwise, I can. How can I say?
And my lord, there is also no record with custody.
Same every day was the same situation we face. So we are in problem. Then I may be granted, my lord. Bail may be granted me. Case of acquittal.
From the face of the case, it is a case of
It will be
equity.
heard together only. That's why I'm ready for hearing, no issue at all.
And more than 2 years, since 2 years, he is in jail, my lord. 7 years conviction.
2 years in jail.
Yes, my lord.
Obviously, reasonable period.
So ultimately, if you get acquittal, even then, my lord, 2 years has gone, and earlier he was more than 3 months.
Oh, this is the last item.
It's the last item.
We are not going to say because I have
I
some
know,
personal.
I have prepared written submission. I will give my friend, my lord.
No, you are not, Mr. Uddin. I am ready. Court is ready to hear. We are not on that. You are ready. We are also ready. We are going to hear. Day after tomorrow.
15.
No, day after
No,
tomorrow.
no, 15, I have another appeal also. Fix.
At 2 p.m. করে দেব।
15 is 14. না, অসুবিধা হবো।
Listen, Mr. Uddin, we will do one thing then. We'll fix it on 21 at 2 p.m. so that it can be heard. Otherwise, it may again left. It is a hearing day. It is a hearing day, 21.
My lord, it may be note, my lord, that last chance, my lord, because my learned
At
friend,
2 p.m. We are ready to p.m. at 2 p.m.
same situation earlier, so many occasions. Same
2
submission.
p.m. also.
Not 2 p.m.,
And
my lord, but
I think that 2 p.m. will create an issue. Yes, that has to be. Yes, yes. You can verify.
21, my lord.
Because it may not be a case for every day for the
Optimum list. The last several occasions they have taken time back. We have not taken only by the last 2 occasions there is possibility of time matter will not be taken. Just it can tell 19 to order. Stated, Lion Council for appellate submitted conducting document has already left the court. Already left the court. We are there now. In 11 to order. On the pair of M. Hawk, Council appealing for the applicant, let the matter be listed of 19 to. And some submissions to be made the best of record, not things going in the air.
Yes, obviously.
We have not taken a single.
Generally, also we have seen that from the prosecution side, adjournment is very few. Yes, there may be some reason or something.
All the adjournments are there, man. Sometimes what happened, though, my lord. And if they take adjournment, that is all. If we take for a single day, then every person. That is kind of good. Last occasion. On 2 occasions, you lost it, the applicant has taken time. Applicant has taken. We have taken not a single time.
The request made by an additional PP, Mr. MP Goswami, the matter is adjourned. However, considering the submission made by Mr. Uddin, the Learned Council for the appellate, let the matter be listed on 21/05/2026 at 2 p.m. And both the parties are hereby asked to proceed with the hearing. Okay, Mr. Goswami, you take the hearing on 21st. Tuesday record at your convenience, and we are fixing it on 21 at 2 p.m. I remind you at 2 p.m. so that it can be heard. Without any adjournment, it will be heard on 21. Because that's why we are fixing at 2 p.m. It's a hearing day. We'll hear the matter. No issue. Up to today also, I was ready. I don't have any issue. But yes,
Otherwise, case is not very long matter.
Maybe
Yes,
long,
madam.
maybe short, that I not know. But the matter is, you are saying that he is in custody for 2 years, so it is a matter of concern. So we want to hear the matter.
Tax case may be short,
But on submission, it may take several times. We cannot say that how many submissions will come subsequently. Text, it may be 3, 4, 5, 6. Submission, delinquent submission, it will go.
Otherwise, it is a case of what POXO, I mean, this 376.
Yes, ma'am. That time, the 2005, my lord, POXO was not that time.
POXO was not there, 376.
Yes.
Oh. So we're listing it on 21/5 at 2 p.m.
No.
It will be heard on that day. Undoubtedly, it will be heard. We'll try. Sometimes it happens in motion days, there are many matters.
Lordship.
Or sometimes 2, 3 hearing matters are listed. So it may not reach in that position.
Right.
So better to list on the hearing day so that may hear, because now we see we are listing 6, 7 numbers of hearing matters. The others were adjourned. So we thought that at least one matter can be heard.
Yes.
But there are some difficulty on the part of the prosecutor.